Hello. Thank you very much, Ms. Sanjali. You can hear me?
Sir, we can hear you.
Okay. So welcome to this session on navigating the liquidation process and the challenges ahead. And I welcome about 20 odd participants have already logged in here. Each one of them is invited to this session, and thank you very much for sparing your time and being with us. I see a cross section of only the names as of now. It will be probably more encouraging and motivating the speaker to see the names of the faces of the participants as well. Because we have issues like network and all internet related issues. But having said and done, if some of the speakers, the participants are able to unmute their video and be available on the screen, that gives a lot of moral kind of support to the speaker. So on this afternoon, we are going to talk about the liquidation process and how to navigate the labyrinths of liquidation, and also what are all the challenges before the insolvency professionals. I'm quite sure that many of the participants here might have already handled quite a few interesting liquidation cases, and their inputs and their insight into the cases would be definitely helpful, because each IBC case, each IBC matter is unique by itself. I hope the participants, Mr. Anil Kupchandani, would agree with me. Am I right, sir? Each IBC matter is unique in its own characteristics, of the case, the promoters, the configuration. Am I right, sir?
Agree with you, sir. Agree with you.
So absolutely. So each one of us today have got certain amount of exposure in interesting cases. And in that context, Mr. Nageshwaran, who is appearing on the screen, he's also an insolvency professional and part of our team. And we have handled together more than 16 IBC matters and gathered quite a bit of exposure in various industries and various kinds of litigations, challenges by various stakeholders. The challenges need not be from the promoters alone. The challenges come from different quarters, sometimes even unexpected quarters as well. So what we are going to talk today, this afternoon, we have tried to put together the process-oriented kind of matters in a very, very simple and concise form. We are not going to take the participants through the entire provisions of IBC and the liquidation process regulations in its complete wholesome kind of a thing, but we want to highlight important aspects. The importance is given to recently coming up issues faced by the liquidators. And I would like to add here, ladies and gentlemen here, the participants, that in a few recent cases of liquidation handled by us, which relate to Section 230 related scheme, compromise and arrangement scheme, quite a lot of challenges have come up during the process. And the time taken during the process itself is significantly, huge, large timelines, and much against the time frames envisaged under the code. So that is the context I wanted to set. Shri, are you ready with the presentation? So to the audience, I would like to start with a presentation which contains about 40 to 50 slides. Am I right?
Yes, 50 slides.
About 50 slides we have. But apart from the slides, we have certain important inputs on the sidelines. and the slides themselves may not give you a complete picture of what I would like to highlight. It is only a pointer. The slides are a kind of a pointer to the issues. So I would like to take the participants through this next 2.5 to 3 hours of our valuable time today, highlighting these important issues in the liquidation process. Liquidation, by the terminology, you can think that it has got different kind of connotations. Yeah, you can skip that. Yes. So in a commercial context of a company successfully operating and successfully making reasonable profit, people will be happy to say that the company is liquid. Am I right or not? The company is liquid. The company is solvent. So a certain aspect of a characteristic attached to the term liquid indicates a positive connotation. So the people will be happy that if you are having a good liquidity in the company. Am I right?
Yes.
But a negative connotation is liquidation. The terminology borrows, the first syllable, but the word by itself, liquidation, okay, liquidation need not per se give a meaning of end of the road, right? You can liquidate an unproductive asset in a company which is doing well, right?
Yes.
So, okay, that's a partial liquidation to improve the financials or solvency of a company. But in the IBC context, the moment the word liquidation has come into IBC, then the liquidation assumes a kind of a end of the road for a company. I don't know whether the participants would agree with the statement on the screen. The screen is visible to all the participants. Nageshwaran sir, can you see the screen?
Yeah, very much.
Okay. So would you agree with me, Mr. Anil? Is the liquidation end of the road for a company? Mithali Shah, you can also respond. Himanshu Kapadia. Well, you have some reservation, I think, to open up on this topic. So liquidation need not be an end of the road for a company per se, because under IBC, I'm talking about under IBC, a liquidation is still more given an opportunity that it can revive itself, it can resurrect itself like a phoenix, coming out of its own ashes. So a liquidation need not spell doom for a company. Liquidation can result in a successful revival of the company as well. It's quite possible. I hope the participants would agree with the views that liquidation need not necessarily be a terminal illness or a kind of a patient, given a certificate that it is no more can survive. That's a kind of a view cannot be taken, particularly in the context of IBC, because IBC in India, elsewhere, probably I think Mr. Nageshwaran has got a good idea of the insolvency resolution process across the globe, particularly in UK and US. In those countries, liquidation means definitely it is a corporate entity unfit for continuation. Would you agree with me, Mr. Nageshwaran?
Very, very much. That is the process, and that is what in those circumstances, the question that is put on the screen is the answer is positive, because liquidation means there is no choice, there is no purpose in continuing the operation of the company.
Correct.
Yeah.
Absolutely.
They take it that is a further inputs, further means money spent on those I mean, companies, things are all something which is an economic waste.
Correct. Absolutely.
That is how it is being taken normally across the globe.
Yes, sir. Thank you, sir. Thank you. And so moving on from this kind of a context for liquidation.
Sir, I agree, because we have handled one engagement wherein which it was an uncommissioned power plant, and the CIRP got failed because it's an uncommissioned power plant. But then the liquidation was handled in a going concern scenario, although it was an uncommissioned power plant. There were a couple of resolution applicants who were shown the benefits of reviving this power plant, and they were ready to bid. And we were able to sell it to one of the large giant of India. So I completely agree that liquidation is not end of the road for a company.
Absolutely.
It can be a way of revival as well.
Yeah. Thank you very much, Mitali. By the way, you are from which place, ma'am?
Sir, I am representing the firm RBSA Advisors, and I'm based out of Ahmedabad.
Ahmedabad.
Yeah.
Oh, very good, very good. Thank you very much for that. Kind of a very apt input, particularly in relation to what is happening under IBC. Sri, can you go to the next slide? So, a brief kind of a road for liquidation. How does it happen in IBC? So wherever there is a resolution plan received, it's a good sign, positive sign. And the next hurdle is approval by the COC. Well, very good. Many of the resolution plans find their way up to COC for approval. And thereafter, the next hurdle is approval by the adjudicating authority. And nowadays, I am seeing a particular trend that there is a kind of a positive urgency to approve resolution plans. At least there is some kind of a monitoring, and is there any resolution plan application pending? How can we take it up and then quickly resolve it? About 2 years ago, I remember many of the resolution applications filed by me, our team, they were all taking its own sweet time. Even now, I have a resolution plan which is pending for more than 3 years. Am I right? Almost 3 years. It is pending. Okay, reasons could be X, Y, Z, but still it is pending. There are stray cases, such instances. But by and large, since when the IBBI started putting in updates in their website, where you can see important events, the date of the event, and what is the important event. I think many of you would have, had the developed, or if not developed, probably required to see the IBBA website on a daily basis. I particularly look at, what are all the important news, and then I go to the orders column under IBBA. What is the disciplinary action taken against one of our fraternity members? That is the kind of thing which, I've been seeing. Like, I can join. So, in that context, the push given for approval of resolution plans has definitely gathered more pace. And there is some kind of an urgency shown by the NCLT benches to close and release the resolution plan approval orders. I hope the participants, who are about 30 in numbers now, almost about 25 IPs will be there. They will agree with my views on this point. So a company which does not get a resolution plan, it goes to the liquidation process. A company where the COC does not approve the resolution plan, possibly, till that timelines, it goes to liquidation. And cases where NCLT has rejected resolution plan. Yes, I have seen. Mitali ma'am, you may remember in one case in Ahmedabad bench, possibly in the last 1 or 2 months before, a resolution plan approved by the COC was rejected by the adjudicating authority.
Yes, sir.
So maybe I think we can deal with, that what is the context in which the NCLT bench rejected that application for resolution plan, we can discuss. So those are all a limited number of cases. Am I right? I have a team of participants from our office, and maybe at the right time we will be having some kind of an interaction on who are all the relevant kind of times we will have some interaction. Raghu, you can, is it comfortable? You can even come here also. So that is the backdrop. So these are all the situations where the company comes into liquidation. Okay, can you go to the next slide? So liquidation process is governed by section 33 of IBC, and there a lot of things have been spoken under what circumstances liquidation shall commence and what are all the powers, duties, obligations of the liquidator, and also kind of moratorium, what is available to a corporate debtor. And as the law evolved over in the last 6 to 7 years, many of you might be remembering that Mr. Mukhopadhyay from NCLAT, he was the chairperson NCLAT, and he was a retired justice from Supreme Court. He brought the concept of Section 230 of Companies Act, a kind of a scheme or a compromise or an arrangement which is contemplated amongst the members of the company or creditors of the company, and amongst them the company. That means the members, the creditors, and the company coming to a kind of a compromise or arrangement. This was envisaged in the normal course, in the corporate restructuring regime. A solvent, healthy companies can, get amalgamated, merged, and sometimes, like, cases like Vedanta. If you take Vedanta, quite a few years ago, there would have been a complete, under one umbrella, many companies would have been there. A little later, the companies would have been separately floated so that each company will be in, some company will be in copper, some company will be in aluminum, some company will be in some other metal. So that kind of arrangement. So those things, like an Ultratech cement, if you take from, the Aditya Birla group. So cement companies are all coming under one umbrella. This is a very, very, useful and very beneficial kind of a provision under Companies Act. So this was combined in a hybrid manner under IBC, thanks to the IBC process and the, I should say, the NCLAT. And thereafter, this picked up in the sense that there is one more kind of a possibility for a company which did not have a buyer in the resolution process. There was no resolution plan, but still another attempt, another lease of life was given to a company through this section 230 of Companies Act under IBC. Now, that is the first line on the slide. The timelines, was given is at the time, 90 days was given earlier as a timeline. Later, what has happened through an amendment, the timeline to submit or file a proposal with adjudicating authority has been cut down to 30 days now. And the adjudicating authority has a kind of, powers to take decision to order further process in the scheme or compromise or arrangement. Now, we will go a little more deeper into this liquidation process, compromise arrangement. Compromise and arrangement under liquidation process, section 230. Sri, you have a separate slide for that process. Yeah, we have a separate slide on that. So here, I think in broad terms, it is stated that within 90 days of the liquidation commencement date, the entire process should be completed is the statement made in 2B, regulation 2B. And the real period of liquidation, which is stated to be 1 year, does not include the time taken for the scheme under section 230. Am I right?
Yes, sir.
Okay, so this is the concept. Any suggestion, any comments, sir? Okay, so why did I put this slide in the beginning? Is that this is the first step in the liquidation process under IBC. The code does not speak about Section 230. Am I right, Raghu? The code does not speak about Section 230. The IBBA liquidation process regulations as well as 39BA. 39BA of CARP regulations, they have introduced this concept of Section 230, and a lot of things have happened, and even a kind of mandatory provision has been added that a person who is giving a scheme or arrangement or a compromise has to be fulfilling the requirement of Section 29A as well. So, well, there is an exemption for MSME companies, the promoters of MSME companies, by virtue of Section 240A, they can also submit a compromise or a scheme. This is happening in many companies. Exactly, they wanted to take back the company on their own terms and, continue the process of the company. So I would like to just take a departure from the 2B, Regulation 2B and Section 230 route under liquidation. The main process, the mainline kind of liquidation process, how does it look like? Can we take a look at the proper liquidation process, not to speak about the Section 230? How does it look like? Can we go there? Yeah. So this is the overall liquidation process. In fact, Sri, I think we have added only one kind of a box exploring Section 230. You'll be able to show it in your cursor there? No. Can it go there?
I think
you can. Not clearly. Okay, on the right-hand side, you can see public announcement claim submissions, and below that in a green box, you can see exploring Section 230, 90 days, 30 days, or 90 days. So this is the only place where I'm seeing our kind of a 230 involvement. Otherwise, by and large, how the liquidation process goes through, entire process, I think our learned participants here would be very well quite aware of the entire thing. Put it in a very, very brief manner. Once the liquidation process starts, the liquidator kickstarts with a public announcement for claims and then collates the claims. And 30 days is the timeline for submission of claims, and he takes another 30 days for verification of the claims. And within the period of 60 days, a kind of set of stakeholders emerge. So that forms the basis for stakeholders consultation committee. Okay, during the 60 days, what happens? Is there no SEC in place, or only liquidator is in charge? If you ask the question, the amendments recently have made it very clear that the COC, which was in existence during the CARP period, will continue as the SEC until the liquidator constitutes the stakeholders consultation committee after going through the process of claim verification. Why this kind of arrangement has been given? If you go to CARP, it is only financial creditors who are in the COC, whether it is secured or unsecured financial creditors. But when you come to the liquidation process, all the stakeholders become part of the stakeholders consultation committee, including operational creditors, including the shareholders of the company. So I'm seeing in many cases, the shareholders do not file their claims. Am I right, Raghu? The shareholders probably they are not aware what is it I'm going to gain by filing a claim for my share capital. Already, the entire funds of the company, assets of the company have gone away. Nothing else is there to recover. Even the secured lenders are not able to realize anything from this company. The haircut is in the range of upside of 70, 80, 90%. So the shareholders think that, they don't have to do any claim filing and all. But in reality, if they file their claim and they become the stakeholders, they get a voting share. And they also participate in the decision-making process. So, sir, coming back to this process of liquidation, so the claim verification, constitution of the consultation committee, and thereafter filing certain important documents like asset memorandum and preliminary report. These are all some important documentation, and these documents can be shared by the liquidator with the stakeholders after obtaining a confidentiality undertaking. And this kind of new amendments in the process, giving more importance to SEC. I think this process has, in the recent few months, this has been happening. Am I right, Raghu? The SEC is given more teams. SEC is given more powers. SEC is given a kind of obligation to get into all these aspects and give their advice to the liquidator. Even though the advice need not be binding on the liquidator, but in some cases, for example, replacement of a liquidator, the SEC has the powers to replace the liquidator, or at least I can say recommend to the NCLT for replacement of the liquidator. Well, so if you just go through the process in a clockwise direction, you have asset memorandum, preliminary report, and then you go to the sale process, realization process, auction, where you come across, the concept of sale as a going concern or parcels or, the kind of different pieces of assets could be in different characteristics. For example, land could be there, buildings could be there, and plant and machinery, intangible assets could be there, financial assets could be there, logo, trademark, reputation, the goodwill of the company, and also sometimes you are not able to recover some dues from some other company, and it is a avoidance transaction. You file an avoidance transaction application, and that application by itself becoming a kind of an asset. Whether it culminates into a recoverable asset or a contingent asset, that's a different question. But even that asset also can be considered as a NRRA provision that is not readily realizable asset category, recognizes such assets. And finally, if at all any amount is realized, then it goes through the distribution under Section 53, the waterfall mechanism. And once this process is completed, then the company either, lock, stock, barrel, it goes to another person as a going concern, taken over by another company, or the assets are, sold in piecemeal. The assets are chopped off in different baskets, and then all the assets get sold. The liquidator has realized the entire money. Now only the shell is there. The company is a shell. There is nothing inside. It's hollow, but the outer frame, the name of the company is there. MCA is having a portal in which it says this is the SIN number, this is the name of the company. So what happens to that company? We have to kill it. We have to put a seal on this company and consign it into the coffins, into the graveyard. So that is a dissolution of the company. So when you dissolve the company, the name and the all the records relevant to that company, it all gets consigned, and no more the company is a valid corporate entity for the sake of any proceedings. So that is the last nail on the coffin of the company, liquidation. So this is the overall liquidation process. And if there is any kind of a comment or any view, participants are free to come out and then they can express their views. Sir, Anil Kupchandani, sir, in case you have anything to say, please go ahead.
Nothing, sir, nothing. It's a good presentation. It's a good presentation.
Thank you. Thank you, sir. You are from which place, sir?
Delhi, sir, Delhi.
Welcome.
Delhi. Thank you, sir.
So you are at the Rajdhani, sir, and probably you can help in the cause of insolvency professionals to in the policy making process. And I believe IBC amendments are on the cards.
Yes.
Okay, so I think a lot of discussions recently, 2 days, 3 days before, there was an IBBI session with insolvency professionals. They wanted to get the feedback from IPs. What are all the challenges, problems, issues you face? Anyway, that's on the sideline. Yes, ma'am. I think I heard, was it Mithali Shah or any other person?
So I had a query.
Yes, ma'am.
Is Section 230 mandatory?
No. Is
And
it
yes,
Kanak Jani?
yes, sir. And if
Okay, yeah.
and the plans that come during the implementation of Section 230, are they
Okay.
equivalent to the one that we received during CIRP? That is, do they have the benefits of extinguishment of claims? I mean, extinguishment of liabilities and takeover of assets at a certain price?
Under Section 230, you are asking, ma'am?
Yes, sir.
Yeah, Section 230 can ask for what is the scheme, how much you are going to pay to the creditors. Definitely, they can include in full and final settlement of this liability, because the liquidator would have shared the kind of total claims on the company. Probably when a scheme comes, somebody is interested in the scheme, it is the end of the CIRP period, commencement of the liquidation period, and the new claims on the date of liquidation commencement might not have come, but the CIRP period claims would have been there in the hands of the IP. Whether the RP continues as a liquidator, then he is having the list of claims. And what I have seen in my experience, one of the promoters who are main stakeholders in the company, generally, they are the people who come forward to submit a claim. So naturally, they have access to the company, they know ins and outs of the company, and they give a scheme. So your question is very relevant. When a person, the promoter, existing promoter of the company, he gives a scheme, whether he is entitled to write in the scheme, I would like to extinguish the liability of 40-50 crores of GST, commercial tax, enforcement directorate. The question is very, very valid. The answer, I don't think it will be passing the muster of NCLT. NCLT will put a break saying that you are not a new management. And by virtue of the scheme, how can you just pass through all those liabilities? But that is one view. The another view would be the claims of such authorities, for example, statutory authorities, they are also in the committee. In the stakeholders committee, they will also be there. And by the time the NCLT orders the first motion process of holding a meeting of the creditors, there they come and cast their vote. At that time, there is a test whether the scheme is approvable by them, is okay with them. And if they clear it, if they also give an objection or a protest in that time, and even after that protest also the scheme is approved, he has a right to come and object before the NCLT. So NCLT, I have seen in a few cases, they are not allowing such kind of a backdoor entry kind of thing. It is not a kind of a possible settlement with the creditors, but wholesale write-off. Maybe I think Raghu and Mr. Nageshwaran, the question asked by her is, a person who is giving a scheme, can they write off all the past liabilities in the scheme?
That is the compromise and arrangement that they are proposing. In the scheme, if the compromise is proposed and the liquidator, the creditors accept that compromise,
okay,
then it can pass through the muster.
Okay. It need not go through the Section 53 waterfall is not mandatory.
Not mandatory.
Okay.
So it is between the creditors and the shareholders or members. The compromise, if it is agreed by the creditors, majority of the creditors, in Companies Act, it should require 3/4 majority approval of the creditors. If that is the case, then the liability can be extinguished.
Okay. Can just put the chair aside.
So can a third party, other than the existing shareholders and promoters, not give a plan in this particular duration of 3 months?
Definitely, they can give. I think there are a number of cases now. A person, a rank outsider, can also give a scheme if he is interested. And in fact, in those cases only, the challenge comes. He will ask, I am not aware of this company, but I've just come to know of it. Please give me all details so that I can give a scheme. Then only the process of getting the claims collation and how that within 30 days and 90 days, the whole process can be completed is a challenge. But your question is good. I really appreciate. Maybe a few cases have to be tested before the NCLT. I have one classic case where all the elements we have discussed is present, in the sense that promoter has given a scheme and he is giving a proposal to extinguish some of the liabilities, or he's paying some token amount. Am I right, Raghu?
Yes.
Some token amount is proposing, and he is a MSME company applicant, resolution applicant. So he is exempted from the 29A, application of provisions, relating to 29AC and H, I think 2 provisions are there. So he is getting an exemption. And we are going to, the creditors have approved. The creditors have approved the scheme, and now it is, going through the second motion process. So it is interesting.
This is interesting when there's an MSME and there's an existing promoter who gives a compromise and arrangement. Now, when a third party is interested in the company, obviously they do not have the entire background information about the company. Can they also participate in this?
Yes.
And give a plan, reducing, of course, the liability, because nobody would want to take it at full liabilities, because sometimes the liabilities exceed the asset value. Yeah. And at the same time, all assets are probably not known to a new applicant, and they still want to go ahead with a compromise and arrangement rather than go for a piecemeal asset purchase. So what is it that comes in these kind of compromise and arrangements?
Quite possible. Yeah, quite possible. We have a classic case again in Chennai NCLT. The oldest case of Nagarjuna Oil Corporation Limited was a very large IBC case, and a completely different third party, Haldia Petrochemicals, gave a scheme under Section 230. The company was in liquidation, and in fact, the same company, Haldia, gave a resolution plan also during the CARP period. It was rejected. It was rejected by the COC, went into liquidation. Haldia gave a scheme under Section 230. At the time, only this Mukhopadhyay introduced Section 230 process came. So he gave, he's a third party. And at that time, they had the idea of, information memorandum, and since they participated in the CARP, they had a good idea. If they had not participated, like you are saying in an entirely different case, they can seek information from the liquidator. That is why there is a kind of a process memorandum or something we have to run during the process. As of now, there is no clear regulations or guidelines as to what kind of a process you have to run for the Section 230 process. Am I right, Raghu?
Yes. But this 30 days and 90 days period, if that is going to be there, it will be a challenge, because as the claim period itself is 30 days, and you will be determining who are all the stakeholders after 60 days. So before that, if they are going to take into account who are all the stakeholders, that will be a check. The timeline will be a challenge for them.
Correct. Yeah.
But now, any person, though the 230 says that the compromise should be between the company creditors and the shareholders, but in IBC 230, under 230, even an outsider who is not connected with the company also gives the proposal scheme, and that has been approved by the NCLTs also.
Yeah, correct. That has been approved. So maybe the number of cases, under 230, definitely the number is not big. I think it will be less than a 2-digit number, I think, or 15 or 10. Maybe I think we have a slide on the statistics as to how many companies have gone through the process under Section 230. So it's an interesting thing. So moving on.
One more question.
Yeah.
The SCC comprises of both the financial creditors and the operational creditors.
Yes.
And all of them have the voting right, including the shareholders.
Correct.
Okay,
yes.
So the shareholders and the operational creditors and the financial creditors all of them have a proportion of rights according to what their credit holding is in the company, the liabilities of the company, is it?
Yeah, correct.
And
Absolutely.
sir, if there are financial creditors, and by the time it reaches, suppose, a liquidation stage, as you just mentioned, that one of your cases has taken about 3 years of time.
Yeah.
After 3 years, if it is going into liquidation, obviously there's an interest component which gets added to the principal sum which was outstanding
Yeah.
at the beginning of the admission. So will
Correct.
that amount also be added to arrive at a proportion of their voting share?
Yes. If it is admitted by the liquidator on the date of commencement of liquidation, then he gets a voting share based on that proportionate amount. It will get added, absolutely.
So suppose if there were employee unions who have a certain proportion and you as creditors have a separate proportion. You mean the employee union earlier, when they were lesser than 10% and would only attend COC meetings, will thereafter have a right, once it's under liquidation, to cast a vote?
Correct, absolutely. Yeah, you are right.
Okay.
Yeah. Ms. Kanakjani, right? Am I pronouncing your name right?
You're pronouncing it perfectly right.
You are from which place?
I am from Bombay.
Bombay. At least may seek one kind of a thing, that the speakers should unmute their video. We would like to see. It's a good question, Ms. Kanakjani, and I really appreciate. I think we are covering this aspect a little bit in the subsequent slides, right? Okay, let me run through. I think Mr. Nageshwaran has got a lot of things to add to this session, because he is a voracious reader of what's going on not only in India, in other countries as well. Sir, we will come back to you a few minutes later onto your views on the entire liquidation process in India. Does it require a complete overhaul, or it can run in the same mold as it is now? And facing all kinds of challenges, even during liquidation also, we find quite an amount of delay happening. Please go to the next slide. So I think we have commented on this liquidation commencement, appointment of liquidator, COC during CRP to function as the SEC during the initial, can I say, 60 days time?
Yes.
And during that time, the public announcement happens, claim comes. Sometime the relinquishment and of security interest also is captured in the claim form, right? This is an important element, because most of the financial creditors who hold security interest definitely will like to hold their asset with them. They would not like to relinquish their asset, right? And in that case, they cannot be a part of the SEC. The creditors, financial or whomsoever, I think in some cases, operational creditors are also becoming secured creditors these days, thanks to Rainbow Papers case. So relinquishment and realization of security interest is an important element, particularly when the SEC is constituted. They can still be a creditor, but they are not a stakeholder. They will not be part of stakeholders consultation committee if they have not relinquished their security interest. Then preparation of list of stakeholders and asset memorandum, preliminary report. All these things happen. Constitution of SEC based on the admitted claims, it happens. Okay, next slide, please. And yes, the growing role of stakeholders consultation committee, we have been seeing a kind of a definite trend empowering the stakeholders consultation committee, much like the COC carries certain amount of powers to decide. Similarly, the SEC has been nowadays, in the last few amendments, they are given the role of advising the liquidator, but at the same time, they are also given a lot of areas where their consultation is required. The SEC, certain papers have to be placed before the SEC, and the liquidator has to seek an advice from the committee. What are all those areas in which the liquidator has to knock the doors of the SEC or place it before the meetings? Fees of the liquidator, appointment remuneration of professionals, and that includes even power to replace the liquidator also. The SEC has the powers. And before you appoint valuers for carrying out the exercise of asset valuation, you have to take the views of the SEC. And of late, I think there is a requirement even to have a meeting of the creditor stakeholders where the valuers have to explain the methodology of valuation, how the valuation has been arrived at. We are trying to make the process more on a transparent manner. A wider consultation is being proposed. Sale of assets also, like marketing strategy. What kind of a marketing strategy the company should, the liquidator should adopt, and how the sale per se should happen, like collective sales or in piecemeal or in parcels. Those things also, mode and manner of sale. And apart from that, the recent addition in this cases are like how avoidance transactions applications will be pursued by the liquidator, whether the creditors would like the liquidator to pursue, or there is no point in chasing the moon and then don't get anything unless you are confident of getting some kind of a clawback. Otherwise, it is a waste of time, energy, and money. So that decision of even saying that we need not have to pursue the avoidance transaction applications, SEC can take a decision. SEC can give a decision to the liquidator by way of their advice, and all these advices carry the 66% of voting. And another important kind of an amendment, a lot of amendments came in February 2024, Raghu. The amendments included even the 230 scheme related amendment, also the 30 days, 90 days. All those amendments have come in February 2024. So participants, ladies and gentlemen, probably I think you will all accept IBBA was playing a lot of proactive role to consult lots of stakeholders, all the stakeholders, bankers, IPs, valuers, and then professionals, resolution applicants, all kinds of stakeholders consultation was going on, and their idea was to streamline the process, cut down the delays, and of course without any casting aspersions. When you call stakeholders, probably IBBA did not have the wherewithal or the ability to do something about the judicial delays. Okay, we will leave it aside for a moment because that is not in their control. So they were not able to really work on cutting down the delays from the judicial side. But they've been highlighting the process, highlighting the timelines, the delay happening to the judicial forum through many interactive sessions, colloquiums. All those things are happening simultaneously. A lot of things are being done. So in that context, one aspect I saw particularly of interest is a going concern. Raghu, can you give a quick highlight? SEC can advise the liquidator as regards how a company which is in liquidation can continue its operations as a going concern during the period. And suppose it makes losses during this period, somebody will suffer, in the stakeholders. Somebody will have to be paid. There is a loss in the operations. So what is the idea of the amendment bringing SEC members into play and saying that you take the advice of the SEC before you decide to continue operations of the company? You are in charge as a liquidator, right? Why do you think it was required and why they made this amendment, Raghu? Raghu, by the way, is part of our team and he's a lawyer, and he takes care of the complete compliance aspects of IBC matters in our office. Yes, Raghu.
Actually, earlier the code gave the authority to the liquidator to continue the company as a going concern even in the liquidation, if he feels that the company can be kept as a going concern.
It is a kind of a beneficial process, beneficial liquidation or something.
Maybe in that process, because earlier the liquidator had the exorbitant power to continue take actions on this, maybe the transparency would have been less reported. That is why this amendment would have come. And recently, the February 2024 amendment states that unless the SEC give clearance to run the company as a going concern, now the liquidator cannot, without the approval of the SEC, they cannot do it on their own. So I feel that it is because of more transparency required by the IBPI. In continuing the company as a going concern, they would have made this amendment.
And it is also possible, Raghu, in the garb of running the company, you may be draining the even available resources also, right?
Yes.
Example, our insolvency professionals here, I have a company in liquidation, and when I inherited that company, into the liquidation process, I had a fixed deposit of about 1.5 crores of rupees. Now, I told the creditors, the SEC members, look, gentlemen, I have a fixed deposit of 1.5 crores, and I would like to continue this company as a going concern, but I would ensure that this fixed deposit is not further liquidated or drawn money from that FD, and it will not be closed, rest assured. That is the kind of an understanding with which the operations of the company were continued. I think Mr. Nageshwaran also is part of our team in the process. Sir, you remember when we were running one exercise in Kerala in a hospital, I think Mr. Nageshwaran being a very conversant person in the medical operations of a large hospital, we took, I think that time this amendment was not there, the going concern. You remember, sir, we consulted the COC members at the time. We would like to run the hospital for some time, then only you can find a good buyer. Am I right, sir? I think can a little bit expand on that.
Yeah, that is actually to continue what Raghu told on that is when a decision is being taken to keep the company as a going concern, the chief, the main aim should be to keep the value of the company much better position so that somebody can come around and bid for it. So that's the idea with which the going concern approach need to be taken. And if it is going to be a further drain on the company, then it was not advisable. That is how the situation was working around. For example, from the time now, what is happening, 2 years, 3 years, 4 years it takes. And during the time, further the deterioration of the machinery, assets, everything is also taking place. And whether that is going to give value addition to the company is always a big question. So there has to be a proper guidance in the entire matter. Now, earlier, the liquidators, as Raghu was saying, themselves were taking the decision, and for right or wrong reasons, they were keeping the company as a going concern. And further losses were also being brought into the company. Even though it is given in the original IBC also that a liquidator should not take a decision to run the company if there is going to be a drain on the company's resources. But it was not really seen that way. Now, by way of this February 24 regulation, very clearly liquidation regulation has come around that the SEC members, because they are the people who are finally going to take the proceeds of the liquidation. If they feel that they are going to get lesser than what they are due today, it is better that they should take the decision whether to keep the company on a going concern basis or not. That is what is the present situation.
Yes, sir. So, yeah, thank you. Thank you very much, Mr. Nageshwaran. So we move on to the next slide. This is again in the liquidation process continuation. Overall, if you see the initial 90 days, we spent on Section 230 related process, and that 30 to 90 days does not constitute the liquidation process timeline of 1 year, right? Okay, so technically the people say that you exclude this portion of 90 days. But in reality, what happens, the 230 process itself takes a year or two easily. So the entire time spent on Section 230 will not form part of the 1 year deadline for the liquidation. I think that is the condition as such right now. It is somewhat odd, to understand the thing. It is companies in liquidation, but the liquidation 1 year timeline has not kick-started yet because we are going through the 230 process. Okay.
But the regulation state that not exceeding 90 days, it is what the regulation state. But how it is, the NCLT gives an exclusion or whatever it is for the NCLT to decide.
Nowadays, what happens, NCLT also takes the LCD as a sacrosanct timeline, that date, and they look at 1 year. Am I right, Raghu? LCD is suppose 1st January 2024. They take end of December as the 1 year period, whether 230 is there or not. And they ask the liquidator, have you sought extension? Have you applied for extension? This is how it is going on right now. And we are also following the same flow. And wherever it is, timelines are nearing to the 1 year, we file another extension application, 2nd year, 3rd year, sometimes 4th year also it is going on now. Anyway, auction process, assignment of not readily realizable assets, and realization, distribution of sale proceeds, dissolution. Though Sri Durga has put everything very neatly, nicely in 5 slabs, so much of issues come up in the process. Not to forget, the liquidator fees. In many cases, the liquidator fee is a question mark. The lenders think that, probably by agreeing to the liquidator fees, he might take, a substantial portion of the amount, which they are not able to realize the assets for long. So they delay, and sometimes, they do not come to a conclusion on the liquidator fees. So that's very, very important from an IB's perspective. We should have a clarity on the liquidator fees. Please go ahead. Timelines, a lot of timelines are there in the liquidation process, but
may I ask one question?
Yes, Mr. Anil. Yeah.
Sir, is NCLT not fixing the liquidator's fees nowadays?
NCLT is not into the liquidator fee fixing process, sir. NCLT is not in the process.
No, but means approval of NCLT is required. Like in CIRP.
No, in CIRP also it is not required. Yeah, you can say, Sri.
In CIRP also it's not required.
It is the
fee or the RP fee is not required.
Prerogative of the COC.
In the case of liquidation, when the COC decides to liquidate the company, either they can fix the liquidator fee, or if they are not fixing in the first SEC meeting, the SEC can fix the.
Okay.
If they have not fixed the fee, then the fee comes on the table part.
Correct.
Which is given in the regulation 4. There is no NCLT approval is required as such.
Yes, sir.
So
in CIRP also not.
Yes, sir.
Yes, sir.
Yeah. Not required.
So in the earlier slide, you mentioned that when there is a compromise arrangement under section 230, it may take more than 90 days and may continue up to 1 year. Why would you say that? Because once the scheme is approved in about 30 to 90 days time, why were you suggesting it can take about a year's time?
Are you in India? The section 230 scheme, I have never seen it's getting approved in 90 days. Approved
may not be by the NCLT, but by the COC, I don't suppose it should be a challenge that, once the compromise and arrangement scheme is, and there's an understanding between the COC, which is now the SEC, and the investor concerned.
Yeah.
If they come to an understanding in about 30 to 60 days time, then they can sign it off. So it is approved at least from that end. May not be from NCLT, but till such time, do you not suppose it will get over in about 90 days time, and then probably, the time takes for its own time. It takes its own time to take approval from the AA.
Okay. Appreciating your view, much like a CIRP where the COC approves the plan within 180 days or 270 days. Am I right? You are correlating it to a
correct
resolution plan approval.
Correct.
In a liquidation within 90 days, if the process is completed. What is the exact wordings of the regulation 2B? I just wanted to highlight the process.
See, the difficult in this process From the difficulty in this process is, since the 230, what is the procedure to be adopted by the SEC or the COC is not clearly defined in the code or regulations. So it is it is in hybrid that some take whatever that is stated in the 230 in Companies Act. And when the liquidator files, even the NCLT in some cases says that you need not have the initial approval of the SEC for bringing this scheme before the NCLT. Whatever schemes come, you place the scheme before the NCLT. Correct. And NCLT gives the order for creditors meeting, and it follows the procedures whatever that has been given in the 230 Companies Act, which has first motion meeting, second motion meeting, all these objections. And it takes a lot of time to bring it to your finalities.
Correct.
So this is the regulation which is talking about the compromise.
Yeah, you would like to highlight, Sri, which point within 90 days? Where is that 90 days you are showing? It shall be completed, where a compromise to be one, where a compromise or arrangement is proposed under Section 230, it shall be completed. So, Ms. Kanak, you are saying that it shall be completed means the approval of the creditors.
Okay.
Are you saying that?
No, I'm saying that if in case you're looking at 90 days, it would be, of course, the creditors. But then you happen to have mentioned it can take about a year's time. This is like, I'm just trying to...
Exactly. What has happened, yes, Mr. Kanak, what has happened in a particular case, I don't know whether it is a stray case or it is a unique case. Anyway, I think we mentioned in the beginning, every IBC case is unique by itself. So in this particular case, what happened? The schemes were presented by the interested resolution applicant, interested scheme applicants, and I filed those schemes with the NCLT. And NCLT started questioning who are all the scheme applicants, do they have enough wherewithal, and the promoter is joining hands with XYZ, whether that XYZ is having some financial credentials, let them come out with some deposit of money to show their interest. So this process itself took about 6 months of time. 2 hearings or 3 hearings. Then they asked the first motion meeting of creditors to be conducted. So they gave an order that you please go through the process. So for that, there is a public announcement. So a clear timeline of 30 days has to be given, 14 days has to be given, and objections received or something, not objections at this stage, but clarifications, anything. So the meeting had to be conducted. So creditors meeting was conducted, scrutinizer was there, and then we filed the approval, the process. That itself took almost about 90 days time. So practically, even to complete the first leg of creditors approval in a 2B compromise arrangement, definitely it is more than 90 days. Am I right, Mr. Nageshwaran?
Very much. It is actually right at the beginning when the advertisement is given for inviting compromise arrangements and things. Then one after the other, people ask for extension of time. Then that becomes an issue that whether to give it or then the SEC decides that you please give the extension because it is better we get the proposal. So by that time, when the compromise proposal is received, that itself takes about 6 months.
But one thing, sir, I would like to add, Raghu, this proviso which was added in 2024.
Yes,
can you highlight that portion?
This portion, the addition.
So that is why this amendment was brought in, because earlier there was no clarity. The 230 was going without a timeline at all, even though it was stated earlier that it should be completed within 90 days. The process was not clear. So that is why this amendment they brought, this 39BA, you decide whether before when you are going to decide for a liquidation, recommend for a liquidation, you decide whether you are going to go for a compromise or arrangement. If you are deciding to go for a compromise arrangement, work from that day itself, do whatever you want, file the application with the NCLT within 30 days of commencement of liquidation. So now it is for the liquidator, because if you see the second proviso, after 30 days, the liquidator cannot file the 230 application with the NCLT.
Correct. It is a kind of an improvement, but I don't know really it works. As it worked in a practical case, we need to see.
Here what the IBBI passes see is that the RP, when this RP, earlier RP who is continuing, if he is going to be a liquidator, in that case, it will not be any difficulty. But supposing a liquidator is going to be replaced in place of RP, then the situation will be difficult for the new liquidator to look into things and file the application within 30 days.
Yeah, correct. And in all these matters, only those companies where some juice is there, an applicant will come, a scheme proponent will come. Otherwise, nothing will happen,
Yes, sir.
So wherever there is some limited kind of assets are there or resources are there, then only this activity of Section 230 is happening. And that primarily I have seen, majority of the cases, it is the promoter. Some odd cases, a third party comes. And third party coming, probably if there is an advantage of a license, in the case of a sugar mill or a distillery or something, they come and try to take the asset. This is what it is happening. And the timelines are not really sacrosanct. That's what I'm seeing. Even though provisions are stating timelines, it does not happen many cases. Okay. So coming to this slide, public announcement within 5 days to be done, and the first SEC meeting to be done within 7 days. And even I think it's a very difficult proposition you were saying, highlighting that valuer has to be appointed within 7 days of the liquidation commencement. Am I right?
That cannot be done at all, sir, because now the regulation says that you take the advice of the SEC for appointing a valuer. Then how it can happen within 7 days when you're going to consult with the SEC for appointing a valuer?
Correct. Last date for submission of claims, this we have seen already. Verification of claims we have seen. Preliminary report also, I think we have seen there 75 days. Okay, next slide, please.
So now on, these are the amendments, the recent amendments which came in the liquidation process regulation. So we'll be seeing the regulations amendments in one by one.
A little bit louder, So 2B, I think we have already seen the amendments, the 30 days and 90 days kind of regulation, which has been introduced.
So I'll go to the next.
Next amendment, early dissolution.
Yes.
Okay, so early dissolution, there was already there was a provision that wherever the liquidator is seeing the assets cannot be realized and they are insufficient to cover the cost of the liquidation process, or the affairs of the CD do not require any further investigation. It's not or, it is and, right?
And yes.
It's an
so
and.
Once this is satisfied, it was earlier, he may apply, like the liquidator himself may apply to the adjudicating authority. Now it has been replaced as he shall consult with the consultation committee. Correct. And if it is advised for the earlier dissolution, he may apply along with the detailed report incorporating the views of the consultation committee to the adjudicating authority. So this is the change which happened in the regulation 14 of liquidation process.
Yeah, they have taken away the exclusive power from the liquidator and put it in the hands of SEC. Okay. It's a wider consultation, transparent process, right? That's the idea. Okay. This is what 31A. So 31A is finding more and more agenda items coming on the table of SEC meetings, right?
Yes.
Okay. So important among them are?
So these are the additions. Earlier it was till E only it was available. Subclause E only was available in subsection 1. Now they have introduced F, G, H, which includes the review of marketing strategy in case of failure of the sale of corporate data as going concern.
Okay.
So this also should be placed before the SEC and it should be reviewed. Continuation and or institution of any suits or legal proceedings by any or against corporate debtor.
Continuation or institution of any suits
or
legal proceeding. That means any case the liquidator wanting to file, he has to go and check with the SEC.
So extension of payment of balance sale consideration as provided in clause 12 of para 1 of schedule 1 beyond 90 days to be disclosed to the auction.
I find this amendment is very good, the last one, because earlier it was 90 days time. The entire liquidation process proceeds has to be paid within 90 days time. And it also stated that earlier, anything beyond 30 days, interest has to be paid. Even the percentage of interest rate also is provided in the schedule. Now, I think they are giving a flexibility here that extension of payment of balance sale consideration beyond 90 days to be disclosed in the auction notice itself. You should give a clear indication that you have an extended timeline to pay.
No, earlier it was not open to the liquidator or the SEC to decide on this.
Correct.
Because of lot of litigation was filed in this matter with the NCLT. Now they want to open and give some kind of a leeway to the SEC to decide on that.
Correct. And I think going down in the discussions, I would like to highlight to the participants the kind of importance the last amendment, that is H, extension of payment of balance sale consideration, how it is very much helpful, particularly in assets which have got attachments or encumbrances in place, but the buyer wants to buy those assets after cleaning up of all the attachment by way of an NCLT order, then I will make the payment. Am I right, Mr. Nageshwaran? Those kind of cases, it comes it comes quite handy.
Very handy.
Yeah. Okay. Next one.
So
yeah.
And again, the stakeholders consultation committee regulation, in sub-regulation 6, they have added 2 more provisos, provided further that the liquidator shall convene subsequent meetings within 30 days of the previous meeting unless the consultation committee has extended the period between such meetings.
Okay.
Even if it is there in any extension given also, there shall be at least 1 meeting in each quarter.
Okay. So this is a kind of putting some standardization in the process so that, I've seen in one of the cases I'm handling as the liquidator, the meetings of SEC happened once in a year, or sometimes even more than 15 months after the first meeting or second meeting. So the stakeholders do not get regular update on even a company, a well-run company, annual general meeting happens once in a year. But in a company where things are going wrong or things are not in shape, unless you meet frequently and as often as required, things will be quite difficult. So these are all some of the amendments to bring a concept of monthly meetings. At the same time, if the SEC feels monthly is not required, you meet once in a quarter, at least one meeting in a quarter is required. Okay. What is this about 6A and 6B? We have seen about it.
No, sir. We have to present the rationale for
economic rationale.
Economic rationale.
Okay. In all cases where the liquidator wants to continue or initiate a legal proceeding, by and large, what happens earlier, liquidator is to file a case or something like that, right? But he has to take an approval from adjudicating authority.
Apart from which is not in the code, he has to take the approval.
Okay.
From the adjudicating authority.
Okay.
See, under the code, we are filing section 66 or any other thing.
Correct.
For that, it is not required.
Correct.
But apart from the code, if a liquidator is required to file any case, he has to take the approval of the AA. But now, it has been suggested that you go to the SEC, provide the rationale and the cost that is going to be incurred and the benefit that is going to be accrued on basis. If the SEC approves that, then you can continue that.
Okay. It's a good, interesting amendment. And the next one, Sri?
In every meeting, the liquidator shall present to the consultation committee the actual liquidation cost along with the reason for exceeding the estimated cost, if any, the consolidated status of all legal proceedings, and the progress made in the process.
Means the liquidation process?
Yes.
Yes, sir.
Progress made in the process.
So all these three items they wanted.
May I ask one question?
Yeah, Mr. Anil.
Sir, can the liquidator appoint the professionals like, CA firm for doing the estimation of the liquidation cost?
Yes, there are certain provisions overriding kind of, there is a circular by IBBA. What are all the occasions in which the liquidator can appoint professionals? And I think it goes to the even CARP also, where all the RP or IRP can appoint professionals. If there is an existing setup of people in the company, in the corporate debtor already, then you cannot, right?
No, sir. He's asking.
Sir, that is for running the company as a going concern, for compliances purposes, yes. But actually for, doing the estimation of the liquidation cost.
Okay. Liquidation
in that
cost.
case.
Okay.
I don't think so, sir.
As a liquidator, primarily belonging to any one of the professions, whether it is CA or CMA or CS or advocate, probably the expectation from IBBA is that the liquidator should be in a position to estimate. But I've seen one provision, Raghu, just correct me, whether it is during CARP or liquidation, if the COC members want an audit to be done on the CRP cost, right?
CRP cost.
In the CRP
COC.
cost, they can engage an audit professional,
Auditors.
right?
Yes.
It is in the CRP process. So what Mr. Anil is asking,
for estimating a liquidation cost, can he engage a firm, a professional?
It is a little bit stretching, Mr. Anil. Maybe
because sometimes, problem is sometimes the company might have, the assets at different places.
Okay.
And then, doing the, estimation of the sale proceed, how do you sell the assets, maybe at a distant location, you cannot anticipate now, maybe take some time. So you might be needing professionals to help to, do the estimation of, about the liquidation proceeds, how to sell the assets and what will be the cost involved in the auction process or otherwise.
Correct.
So maybe, I don't know. That's why I was asking.
No, sir, I think you have made a very, very relevant point. A liquidator may appoint professionals to assist him in the discharge of his duties, Regulation 7. In the discharge of his duties, obligations, and functions for a reasonable remuneration, and such remuneration shall form part of the liquidation cost. The liquidator shall not appoint a professional who is his relative or a related party. Okay. A professional appointed or proposed to be appointed shall disclose the existence of any pecuniary or personal relationship. All that is fine. So there is a provision that a liquidator may appoint professionals to assist him in the discharge of his duties. So what you are saying in a situation of a multi-location company.
That is good, sir. I will just explain. Sir, this regulation 39B of CRP regulation states that when the committee decides to liquidate a company, they make a best estimate with the consultation of the RP.
Okay.
So this estimate of liquidation cost should be made in the CRP period process itself.
Okay.
So I don't think there is a requirement for appointing. If supposing that is there, COC during that period, CRP period, approves if that is the difficult case to estimate the cost.
Correct.
During that period, it can be done, I think.
I think this amendment came even 2019 itself.
Doing the estimation during the CIRP process, I think is too premature. I mean, liquidation may happen, may not happen, and at what time it's going to happen, nobody can, sort of anticipate at that point in time.
So, sir, this estimation is it's an estimate, and wherever there is an escalation, you are going to give a reason for that, why it has been there in the progress.
Of course, justification will have to be given. Justification will have to be given.
because we cannot envisage whatever entire thing. It cannot be envisaged. It can be only on a best estimate basis. We can do an estimation for a liquidation cost, and if there is an escalation, we'll have to give a justification.
Sir, Mr. Anil, there is every possibility that COC is approving a resolution plan. And there is a possibility the resolution plan may not be approved by the adjudicating authority. Would you agree with me, sir? COC may approve the plan.
Yes, sir. Yes, sir. Yes.
CLT may not approve it. So that is why the code, the regulations, particularly the CARP regulation says, even if you are recommending a resolution plan for approval, plan B, you do this exercise also, estimating the liquidation cost in the event the plan is not approved. The company is going into liquidation. So that is the kind of, the responsibility on the RP and the COC. Even if you are recommending a resolution plan approval, application to NCLT, please do this exercise also, they are saying, so that there is a continuity in the liquidation process. So the point Mr. Raghu is telling, there is a base document which should be available with the liquidator as estimated by the RP during the CRP period. But your point is that it might have been the best estimate at that point in time. Now changes have happened. So according to my understanding, sir, if there is a need for such engaging the professional, yes, definitely you have the right. But only thing is, you do not have an exclusive right to appoint the person on your own. To please place it before the SEC and take their advice, then you appoint. Am I right, sir? That is the kind of intention on the code and the regulations. So I think, sir, in many cases of disciplinary action by the IBBI, I have seen quite a lot of cases where monies have been paid, huge monies have been paid to insolvency professional entities. Okay, so those cases have come up for questioning whether it is reasonable amount. I think quite a lot of disputes and discussions went on the fees paid by the RP and the liquidator for various professionals. That is why IBBI came up with a detailed, you call it a circular or what is that, notification. They said, these are all the liquidation costs and these are not liquidation costs. This should be done, that should be done. And even in some cases, the 6 months timeline, the slab rate for the fees, cannot be automatically changed. Then it has to be approved. All those things of clarifications came from the IBBI. So IBBI is more into transparency on this process. So definitely, I think any professional you want to engage, it is better to justify it. But at the same time, if it is required, then you can definitely have it for a beneficial liquidation. Can you go to the next one?
No, sir, not 9. For 9, they have given an explanation for the term voting. Voting means the voting cast by the representatives of the consultation committee.
Okay.
So earlier this explanation was not there to the sub-regulation. Now they have added this explanations.
Okay. So the importance of this, Raghu, present and voting.
Yes.
Right?
Yes.
It is like a company, normal company in a general meeting, shareholders voting. Even if there are 100 shareholders, if only 10 shareholders are present in a meeting of the company and their shareholding is taken as the 100%, right?
No, sir. I see that because it says representative because the SEC now is being represented by a group of, because SEC says, the constitution of SEC says,
yes,
a group of creditor should be represented by one representative of each class.
Right.
So this voting, cast by the representative means that one representative, if he votes, it is for the entire class.
Okay.
That is what I mean by this explanation.
Okay. So even otherwise, before amendment also, the consultative committee shall advise the liquidator by a vote of not less than 66% of the representatives of the consultation committee voting, right?
Yes, sir.
What was the need for this amendment? You said by the representatives, huh?
Yes, sir.
The term voting shall mean voting cast by the representatives of the consultation committee. The consultation committee, there can be many representatives.
Yeah.
And they represent 5 or 6
class of
creditors there in that.
Yes.
The total of them the
yes.
voting share kind of a thing. Okay. Okay, yes. Next, please.
So as like in regulation 32, in sub-regulation 4, they have given explanation. For the purpose of this sub-regulation, it is hereby clarified that the sale of the corporate debtor under clause E of regulation 32 cannot be offered as the only option for the bidders after the first auction.
Okay.
So after the first auction, the batch sales was also...
Other assets in parts and parcels should also be offered after the first auction.
Yes, sir.
You can again put the company as a going concern in the second auction also.
But it cannot be the only option.
It cannot be the only option, right?
In order to see that the process is being carried at pace,
okay,
they want to make it.
Okay, so that is in the sale of assets.
Otherwise, we will be going that the liquidator will be publishing the 3-4 advertisement for going concern only.
Nothing comes out.
Nothing comes out.
Yeah. Okay. Okay. So that is an intentional kind of a thing to speed up the process of
and value maximization.
Okay. Okay. Next one.
Actually, we discussed this point earlier. When the liquidator is of the opinion that it is viable to run the corporate debtor as a going concern, he shall consult the consultation committee, and only on its advice he shall run the affairs of the corporate debtor as going concern to the extent approved.
Okay. Yeah, we talked about it. So there has to be complete sharing of information by the liquidator with the committee. What is it I'm going to do by continuing the operations? What is the plus and minus of it? And to what extent the SEC approves, he can go ahead, right? Okay, next, please. Mode of sale. Yes, in this case, what happened, this is a private sale related provision. Earlier provision has been slightly modified now. It says that the liquidator may sell the assets of the corporate debtor by means of a private sale only after prior consultation with the consultation committee. Earlier, it was not there.
Yes.
So now they have added, yes, you can do the private sale in certain cases, but even in that certain cases also, you consult the SEC. That is the idea and intention. So what are all the cases where they can sell the assets under a private sale? Assets which are immediately perishable and you cannot wait for long, and asset is likely to deteriorate in value significantly if not sold immediately. Okay, the first one is perishable. I don't know, the second one also has characteristics similar to that, right? Likely to deteriorate in the value significantly if not sold immediately. The earlier one perishes, there is no value there.
Yes.
Value gets destroyed. But the second one, value gets deteriorated.
Yes.
Okay. So degree of this thing slightly varies. Okay. So the third one, they have removed Sri.
Yes.
The asset is sold at a price higher than the reserve price of a failed auction. So that option was there earlier. This has been removed now. And the prior permission of the adjudicating authority has been obtained for such sale. What do you mean? If the asset is perishable, I still go with the consultation committee, I can sell.
Yes.
I need not go to the adjudicating authority again.
If it is for the related party, you need to go, sir.
If it is related party is separate.
Yeah.
But here, the prior permission has been obtained for such sale. What is that?
No. If it is perishable, without the adjudicating authority approval, the liquidator with the consultation committee approval can go.
Very good. Very good. In the second case also, with the SEC, you can go ahead and sell, but all other cases, you still have SEC's consent and also prior consent.
Yes.
Is that the understanding?
Yes, sir.
But is it coming out well?
No, this is for a private sale only, sir. Otherwise, the Schedule 1 says normally the liquidator should sell through an open, transparent manner.
Auction.
Yes.
Yeah, auctioning process. Okay. So it says that the liquidator may sell the assets of the company by way of a private sale after consultation with the SEC if it is a perishable one or if it is likely to deteriorate.
Yes.
Up to that, it is correct. Come, please come. Up to that, it is fine. The third element, seemingly, does it add the requirement of prior permission also? I was just thinking like that. Idea is it is not required. For those two cases, it is not required.
Not required.
Otherwise, what was the one which has been deleted? Asset is sold at a price higher than the reserve price of a failed auction. So I went for 2-3 auctions. I could not sell, right? But some offer has come at a price higher than the reserve price, right? And that fellow has come afterwards. So I am going to sell it to him. Then in that case, prior permission of the adjudicating authority, was it required earlier?
No, sir.
No, it was not required earlier. So they have removed that.
Yes.
They say that in that condition, you please report it to adjudicating authority. Otherwise, there can be instances of, a kind of scheming or a gaming kind of a thing. You put 2-3 auctions, it will let it get failed. Then I'll give a slightly improved amount. Then we'll close the matter. Probably,
yes,
that kind of a thing might happen. That could be the possible
the
idea.
IBI point of view is they are bringing in more transparency.
Yeah.
In the every process.
Correct. Yes, Sri, we can go to the next one. Valuation of assets of business intended to be sold. In cases not covered under sub-regulation 1, that is the valuation requirement, or where the liquidator, after consultation with the SEC, is of the opinion.
The sub-regulation 1 talks about the valuation that the liquidator is going to consider,
right?
Which has been taken during the CRP periods.
Okay.
So if it is not then the fresh valuation has to be taken.
Okay.
In that case, this amendment.
Okay. So there again, the amendment requires the liquidator to go to consultation committee and seek their advice. Right?
This is where we said that the consultation committee
within 7 days.
First consultation committee is to be held within 7 days, and whereas this 35 says that you will have to appoint within 7 days of liquidation commencement date. There is a mismatch in the timeline which cannot happen within the 7 days.
Correct. Okay, please go ahead. Okay, so this is again the entire set of amendment is from February 2024. Okay, so this is speaking more about the methodology to be discussed with the SEC.
SEC members.
Okay.
Before finalizing the valuation, the valuer has to give what is the methodology they have followed. They will have to have a meeting. They'll have to have a meeting. In that meeting, they'll have to explain and justify that. Things. Thereafter, they'll have to give.
Okay. So they can share, the valuation reports can be shared with the committee members after taking confidentiality undertaking. This provision was not there earlier.
Yes.
Right?
Yes.
Okay. So in case there is a deviation of 25% in the valuation of an asset class from the valuation under Regulation 35 of CARP regulations, right? The liquidator shall facilitate a meeting wherein the registered valuer shall explain the reasons for the difference to the consultation committee. I think in CARP, if you go back, they will say if there is a significant variation, which is 25%, go for a third valuer. So here they are saying not
there is a comparison between valuation from the CRP period and the liquidation period.
Correct.
Where the difference is more than 25%. Explanation is required.
Okay. So the explanation can come from only the recent valuers.
Yes.
The present valuers come and explain.
Yes.
And they should be given this CARP valuation report. Then only they can explain. The registered valuers shall explain how they will explain. Will you give a valuation report of the previous valuer to the present valuer?
No, sir. No,
so how do you feel?
It is an independent exercise. But this what you are saying is right. From where they will have a comparison.
See, you are a chartered accountant, and you are asked to compare, this year balance sheet with the previous year balance sheet audited by somebody else. Okay, they would have given you that numbers and all. It is fine. If that number is not at all there, and suddenly you are asked to make a comparison or convince or explain, the valuers shall explain the reasons for the difference to the consultation committee. Okay. The valuers will think, these are all some of the pitfalls or possible unnecessary kind of role for them. Additionally, after they complete the valuation report, yes, they give the bills.
It is an independent exercise, valuation, because every valuer has the reason for his own opinion, whatever he is estimating.
Okay.
So here, explanation to be given for the difference in value of the earlier, I don't think.
Okay. Yeah.
Sir, I have a question. This valuation report which you are talking about is before signing by the registered valuer, like draft report we are talking about, like he has to explain because it says before finalization of valuation report. So is the draft report submitted by registered valuer which you are talking about?
No, sir. There is no question of draft report at all. Only in the first meeting, they will have to explain the methodology being adopted. The value will not be disclosed at the meeting.
So this is the signed report submitted by the registered valuer. Finalized.
Yes, sir.
Yeah.
Okay. Thank you.
You can I think read the first paragraph. Liquidators shall facilitate a meeting wherein the RVs shall explain the methodology being adopted to arrive at valuation to the SEC before finalization of valuation reports. Before they finalize it, they will come and explain to them. Sir. At the time, there can be an exchange of information. Thereafter, he finalizes and he gives it.
Yes, sir. There, they want how the what methodology is being adopted.
Correct.
Whether it is, they have a 3 set of methodology.
Correct.
And which methodology is being adopted for this case, and they'll have to justify why they adopt that methodology.
I think, Mr. Rajesh, in many of the cases I have seen, the valuers will take a position, right? They will say, sir, according to our guidelines and our standards, I will do the valuation. Please allow me to do that. Please do not say this way, that way, and all, because it will amount to a certain amount of influencing the valuation, right? So they are also having certain code of conduct and other things. So I think the drafting of these provisions, you can see the words used: facilitate, shall explain the methodology. That's all, right? And they cannot be guided by the SEC. Am I right, sir?
Yes, sir. Yes, sir.
Yeah, because it would be quite conflict, and because every valuer has his own opinion and methodology. So
correct, sir. Correct. Absolutely. Sri, how many more slides you have on the amendments to process regulations? Is over now?
No, sir. We still have some.
Run through. I think we are now.
4 more slides on.
4 more.
Yes.
Okay. This is not very material. This is a corporate liquidation account related to that. I think a similar kind of an amendment was made in the CRP regulation also. So wherever there is some kind of claim or something which the liquidator cannot complete or disburse the money, then he is supposed to remit it to the corporate liquidation account. And before the dissolution application is approved or something, in between some claim comes, then the liquidator is required to facilitate such claims. Am I right, Raghu?
Yes, sir.
So 7A, B, C, yes. D, E, all those related to that. Okay, next one. Corporate liquidation account. The board may, if satisfied as stakeholder or any person referred.
Continuation to the earlier regulations. Earlier it was only 7, okay. So now they have specifically given us 7.
Right. It's a continuation. Okay. Exclusion of certain assets from the liquidation estate.
This is real estate projects.
Yeah, this is relating to the real estate project where certain allottees to a real estate project, they have been already given possession of the allotment. Such assets shall not form part of a liquidation estate of the corporate data. It is a kind of a relief to the real estate home buyers where they have been already taken possession of it. Okay.
So with this, the amendment.
Very good. So, ladies and gentlemen, we are now, we started this session at 2 o'clock, right? So, we are halfway through the mark and little 10 minutes ahead. My team members are suggesting to have a 10 minutes biological break. So, what we will do after the break, Raghu, challenges which are faced in the liquidation process, right? Broadly, in about 5 or 6 heads, what are all the challenges coming? And thereafter, Sri?
We have some case loss.
Case loss, important case loss, which we have noticed in the recent past in the liquidation process. And we have a team members, Ilamati is a advocate and company secretary. She's just to my left. So, Ila, I think we can have major decisions in the liquidation process affecting, like 12A is possible or not, and security interest during the liquidation process, and presumption of security interest. I think that's very interesting. There was one case law with Canara Bank decision by NCLAD judgment. So those are all some areas which we would like to share it with the team members, and also on the Section 32A protection, to what extent is helping in realization of the assets. And NRRA, that is one more area. Onerous property and IBBA clarification on liquidators' fee. I think that has gone through some judicial intervention and judicial.
Thereafter, the circular itself has been amended.
Amended also. So private sale during liquidation. These are all the areas. Nageshwaran sir, we will meet after 10 minutes. Mr. Anil and other participants. So Gupta, you have anything to ask, sir? Mr. DP Gupta?
Sir,
Yes,
can I
yes,
put in a question?
Yeah.
Going concern. Suppose you are selling the asset as a going concern during liquidation.
Okay.
Now, if suppose there is an income tax, otherwise income tax liabilities do get extinguished. But if it is a going concern, there are likely to be demands raised by the income tax department, or anti-evasion notices from the GST, suppose, or any other tax department for that matter. Will those continue, or if they haven't raised a claim, will they continue, or will they also get nullified once you offer a certain price?
Yeah, good question. There are interesting case laws on this matter, and at least immediately I can recollect 2 case laws. Ila, you remember that Mamta Binani matter of Sterling Biotech versus Perfetti. What is it?
Pfizer.
Perfetti.
Pfizer.
No, that chocolate manufacturing company. Perfetti. So that is a case where it was, the Sterling Biotech, which manufactures, gelatin, which goes into the capsules of medical purposes. That company was bought in liquidation as a going concern, and the buyer is from abroad. He put conditions in the terms that I'm coming to India and I'm taking over this plant and I am entering this country for the first time. Please give me this reliefs. Your tax authorities, all those people should not come and haunt me. I should have a clean slate. Everything was put on that, and it was finally approved by the NCLT. So to answer your question, Ms. Kanak, yes, it is possible in a going concern, removing all liabilities, claims and other things, extinguishing them, and then starting on a clean state. It is very much possible.
Provided there is a new management who is taking over.
Exactly, provided there is a new management. But before you joined us, there was another kind of a discussion. Even if I am not a new management, whether I can give extinguishing certain liabilities, because that creditor is also in the SEC. He is approving the scheme. So what harm even for the existing management?
It is for compromise and arrangement.
Compromise and arrangement. The compromise.
So when they are settled once through a scheme, or once they are settled by way of sale as going concern, it means their dues has been considered and they are settled in full.
Correct.
So irrespective of the amount they will be getting, it means the other claims are extinguished.
Correct, exactly. So Ms. Kanak, what I will do, I have one more interesting case on this same point. which we will probably discuss. It is a Madras High Court judgment. I think it is in the case of National Sewing Threads versus Tangent Co. Yes, sir. In case you have read that judgment, it will be good. Otherwise, we will just take 10 minutes to explain. It's a very beautiful judgment, and it is taking IBC apart. It is ripping IBC apart, that decision of Madras High Court. Okay, so we'll take 10 minutes break, Mr. Nageshwaran and other participants. Thank you. Can you see the... Thank you, sir. Thank you, ladies and gentlemen. We resume the discussions and the session on the points which, before we break, we took a break. I think Ms. Kanakjani was asking about going concern under that concept, whether the person taking over the company will have reliefs from income tax and other taxes. We concluded that yes, it's quite possible so long as the person taking over is the new management. And interestingly, there was a case in Madras High Court where a company went into CIRP process and the promoters gave a resolution plan because they were exempted under Section 240A being MSME, and the plan was approved by the NCLT. And as per the plan, all the payments were all made to every creditor. Tangetco was one of the creditors. Who is Tangetco? Tangetco is the Tamil Nadu energy electricity distribution company. So this company had electricity connection earlier and certain dues were there. And in the resolution process, Tangetco did not give a claim. And this company said that all the claims have been extinguished on the date of the resolution approval, and Tangetco cannot come back with that money. And when the company went to Tangetco for power connection, restoring the power connection, they said, unless you pay the past dues, I will not be able to give you connection. So naturally, worried by the stand taken by the Tangetco, this company, unusually, they went to High Court. I don't know why they went to High Court. They should have probably come to NCLT itself, and then, based on the decision of NCLT, they should have taken the next course to NCLAT. But they went to High Court. And in this particular order, which is National Sewing Thread Company versus Tangetco, the High Court bench made several kinds of observations. In fact, they took a complete deep dive into the IBC provisions, and I think they fought for the operational creditors in particular, who are not in the committee of creditors, but their fate is decided and sealed by the committee of creditors, who are essentially financial creditors. And the bench would have gone on to say that RPs, IRPs, and liquidators, they should have at least the basic knowledge where there is some land, where there is some electricity connection, some past dues are there or not. They should have approached the people. If Tangetco has been there, what is the problem in asking Tangetco, do you have any outstanding relating to this period or not? So if Tangetco has not given the claim, if the municipal authorities have not given their claim, that doesn't mean their claims are all gone forever. And in fact, you would have taken a dig at the authorities if every company during IBC says that past dues of electricity companies need not be paid, how that electricity company will survive, how they will provide power to the people, to the industries. So insolvency professionals need not be Harvard-educated professionals. I think they should, play their role in a proper way. They should ground themselves to the reality, and then they should work out all the things. Ila, you would like to add something on the case, how it went?
Yes. So it was a very lengthy judgment with a lot of observations on the code as such. In fact, the bench also would have had a question as to why the bankers came into IBC process instead of proceeding under SARFACI. Because the court would have had an observation had the company been brought into only SARFACI proceedings wherein the asset would have auctioned, operational creditors, including Tangetco, wouldn't have suffered. They would have finally had an opinion that no relief can be granted. Tangetco payment will have to be done. It was the company's duty to make this disclosure about the dues which is pending to the operational creditors. Even the earlier management would have failed to disclose it during the process. And the RP and IRP also wouldn't have considered the claim as such. So the bench would have had an opinion that the electricity dues will have to be given priority, they have to be paid, TANGEDCO will have to be settled to resume the power connection. So this is kind of a clarity and also an eye-opener for the banks to take a right decision on how to initiate proceedings for a debt and default manner. So I think the court was pretty clear that purview of IBC is to balance everybody's claim, to have a rational decision by the RP or the liquidator during the process, and not to be unilateral or arbitrary anywhere, just to go by the letters of law. The spirit will also have to be upheld.
Absolutely. I think if time permitting, the participants, ladies and gentlemen, please do read this judgment. I think it is making lots and lots of scathing remarks, not only on the insolvency professionals, on various stakeholders, even including the people who have drafted IBC, how it has been drafted and how operational creditors have been dealt with in the code. That's a very interesting kind of thing. Yeah, you please go ahead with the...
So there is a small question here. Even if, the electricity department was an operational creditor, according to section 53, if there was the waterfall mechanism was being used for making payments, and if there were no funds left for making payment to these operational creditors, then in that case, what could, like whether you've given a claim or not given a claim is a separate story. If you had not given a claim and there was some contingent amount which was kept aside, then too, they would be only paid in proportion to what could have been paid otherwise if they had been claimants here. It couldn't have been 100%. And of course, if it's the erstwhile management, the challenge is they cannot, request a haircut at the expense of all the creditors and again revisit the company via backdoor entry, as most of these tribunals have observed. So if it was a third party in this case who was not aware or, who had given his funds, he cannot be penalized for something like, somebody waking up at a much later date and asking and demanding values.
Exactly, exactly, Ms. Kanak. That is why the High Court went on to say, you were one of the directors of the company, you were aware of this TANGEDCO, and you should have told the insolvency professional that there is an amount of so much dues to be paid to the TANGEDCO. You didn't share it. You didn't tell the RP. RP himself should have done that. He didn't do it. So you people, all of you, do this kind of resolution process, and you leave high and dry a utility company. This is not correct. Maybe you are right, Ms. Kanak. We are not able to see you. We are happy to hear you questions. Maybe we would like you to unmute. Yeah, thank you very much. So in this case, you please go through this order. It is very interesting because they happen to be the original promoter, and who took over this company, and the High Court came down heavily on him. And
so can you just repeat the case law once again? Can I just note it down, or maybe if you are sharing it
we can put it in the chat box as well, just for the sake of repetition. It is National Sewing Thread Company Limited versus TANGEDCO.
Fine. So Section 230 scheme under Companies Act, I think, Sri Durga, we have discussed enough on that kind of a thing. Challenges. And no, once again, the earlier, so you are coming back to these things. Okay. So I think 39BA, we talked about it. 2B also, we talked about it. And Companies Act Section 230 is a provision which applies to all types of companies, including solvent companies, and enables merger, demerger, amalgamation, etc. Yeah, absolutely. So IBC takes a detour into Companies Act for some time and then come back to IBC, right? That is how the thing hybrid or high-tech kind of a thing has been designed. Unfortunately, because of lack of clarity in certain issues, take this for example, should Section 53 waterfall mechanism be followed in the Section 230 scheme, allocation of the funds, whether the liquidator is going to do the allocation or the scheme proponent is giving the allocation. So the answer or the kind of reality what is happening is the scheme proponent is distributing the money. He himself is distributing the money. And it is not strictly as per section 53, because if he does as per section 53, whatever little amount he is offering will go only to secured lenders. Nothing will flow to the other people. So here, I think to some extent, it is softening the blow on the operational creditors. And whether commercial wisdom of the creditors is applicable under 230 scheme is again a question mark, because in CARP, section 31 is talking about commercial wisdom, but in section 230, whether commercial wisdom of creditors will be binding on the scheme, and the adjudicating authority is bound by the commercial wisdom of the creditors to approve section 230. Probably this is to be tested, Ila.
It should be. It should technically be, because there are a lot of terms which the proponents have been incorporating in their scheme of late, because people are taking this route for, at convenience. So 230 has been increased in IBC processes now.
Slowly, I think there is more number of cases coming under section 230. Yes. Yeah, people are looking at it as a good option. Let's see. Okay, then. Security interest interplay between IBC and Companies Act. I think this is an interesting case where IBC recognizes only these three aspects of proving the security interest. Am I right?
Yes.
Information utility records, registration with ROC, that is under section 77, and CERSAI registration. So what happened in one case where a secured lender had the registration under Transfer of Properties Act, that is the normal Sub-Registrar Office registration, MOD, Memorandum of Deposit of Title Deeds. But he did not do any of the three. You go back to the other. This is the case you are explaining. Okay. So the three modes of proving security interest, he did not do that. So in this case, which happened to be a case handled by me as a liquidator, I admitted the claim of the bank as secured creditor during CARP, because section 77 of Companies Act will clearly say that no charge created by a company shall be taken into account by the liquidator unless it is duly registered with ROC. So it is by the liquidator. So during the liquidation process, I cannot treat him as a secured lender. So in CARP, he was a secured lender. In liquidation, I made him unsecured lender. So he went to the court, and NCLT said, liquidator is right. So he has every authority to reject reject you as a secured lender. You are no more a secured lender. They went to NCLAT. Next page. So in the NCLAT, the question was taken up, and the bank made an observation to the bench that I am a nationalized bank, public money is with me, and this liquidator is making me unsecured. How is it justified? And I have already done the mortgage under Transfer of Property Act, which is 1882. And the liquidator, unmindful of these things, he's talking about Companies Act and IBC, and he's trying to override the validity of the Transfer of Property Act registration, which I have made. So in this case, the NCLAT, you can say, you were arguing this case before NCLAT.
So NCLAT had a view that the rights of a creditor, of a secured creditor under Transfer of Property Act or SAFEC Act shouldn't be diluted by way of this Regulation 21. But still, on the letter and spirit, the regulations do provide only three modes by which the claim can be verified, wherein the security interest is to be proved. One other aspect is under liquidation, when a creditor is having a security interest, the creditor is given right under Section 52 to go and realize the asset. So in that case, when the matter comes to Section 52, the liquidator will have to verify whether there is a valid security interest, for which the Regulation 21 gives a guidance that there are three modes to prove it. And when the asset is not covered into this 3 to prove it is being secured, then naturally the claim should have been determined as unsecured. But the regulation 21 was given a wide interpretation in this particular case by NCLAT, and it was given the creditors were given a window to register under other acts and also get a shelter as a secure creditor in IBC. But as a good advice, as a good practice, it is better if the bankers go and get their security registered as per Companies Act, or at least with the information utility, so that their rights are protected as a whole under IBC.
Absolutely. Yeah. Next one, please.
So
this is the same thing,
yes,
mortgage.
This is
21A also the same thing, we talked about it. Yeah.
this we discussed earlier, sir, regarding the valuation of the asset.
Okay. The consultation of SEC is required. Yeah. Okay.
Within 7 days, and the valuation, first valuation is also within 7 days.
Go ahead. The point was that is it possible for the liquidator to do all these things within 7 days? That's the challenge. Yeah, stakeholders consultation committee. This is one aspect, Raghu, where the secured lender is not relinquishing his interest.
Yes.
So he cannot be part of SEC. So some decisions minus the secured lender, the other parties are taking the decisions, right? So,
sir, in the 230 case, supposing a 230 case is being considered during the liquidation process, the secured creditor who has not relinquished his security interest will not form part of the SEC.
Correct.
But he will not be, since he is not part of SEC, he will not be in the decision-making process of the 230, which is being considered inclusive of his security interest.
Correct. However, I think in the specific order given by the NCLT, I think there they are recognizing the role of the secured creditor. So in the order given for the first motion meeting, they have given, I think it is on a case-to-case basis they are doing it, I don't know, or on a template. So secured creditor interest being paramount, they should be considered, their interest or their concern should be considered in the meeting, and the voting share, it should be included. Something like that they have included in the order, NCLT order. But I think by and large, they could have made a separate kind of a guidance that in the event of a 230 scheme being considered as a first motion process, all creditors, whether they have relinquished their interest or not, secured or unsecured, operational or financial, everybody who is a stakeholder.
Yes.
But he should have given a claim, am I right?
Yes.
Yes,
Without giving a claim, then he cannot come and ask questions, right?
Correct.
So, many cases, the shareholders, they don't have a proper idea or something like that, they don't give a claim.
Correct.
So they, at that time they wake up and say, I'm a 30% shareholder, I'm a 40% shareholder, kind of a thing. But I think there are certain gray areas. If it is a pure black and white, like the screen which appears, things would have been better, but gray is always, can be interpreted in many ways. So this is one challenge. Next, protection under 32A. 32A1 talks about the protection to the corporate debtor when there is a change in management. And 32A2 is talking about the protection to the assets of the CD. Raghu, the challenge which we have been facing is attachment by authorities, government authorities, income tax, Binami.
Enforcement Directorate.
Yes. Now, even though there is a protection available, if a third party, not the existing management, another new management takes over, there is a protection.
Yes.
And 32A is not even contemplating an application to be filed and relief to be given. Am I right?
Yes.
Yes.
It is a straight jacket, straight away it is eligible. You are eligible, the CD is eligible, the assets are eligible. But I think whether it is enforceable only when there is a resolution plan approval.
Yes.
Second one, there is a sale during liquidation process. Do you think this is appreciated by the buyers of encumbered assets? If this is really working well, if this 32A is very good, is very effective, all attached properties, people will come and buy now because there is a 32A, which is not happening. Why?
So they take advantage of that. This 32, the assets, the encumbered asset, the value, they decrease the value and they take advantage of that. But they know that the 32A protection is there, NCLT, once it is approved. But value maximization for the creditors is not happening because of this encumbrances.
Correct. And
by and large, the people who are willing to take the risk will be minimum, sir.
Yes. Because there is always an ambiguity in this,
yes.
whether it will be approved, whether they'll get the full protection, what if there's a further claim, time taken,
timeline, yes.
So there's a lot of ambiguity, but still that provision attempts to give an immunity. So the the buyer will have to do proper due diligence.
And the persons who are buying such assets, finally they will be opening their purse to make the payment only after an NCLT order is clearly saying that this is removed, that is removed, it is a clean slate, nothing to worry, I'm giving you guarantee. That kind of an order they are expecting.
Yes.
Okay, good. Next, Sri. NRRA 37A regulation. Recently, recently we have faced a case. One company which is into liquidation, the liquidator is seeing that there are certain avoidance applications, and he wants to assign those avoidance applications under NRRA. And a bank is buying those NRRA. Is buying or receiving, I don't know. NRRA, there has to be a consideration for NRRA or no need?
It can be either a consideration or whatever which is going to be given to me. Recovery.
Okay.
Yes.
I think it is like a sweeping the floor. Finally, this is left out. I am giving it to you so that I can close the company.
Yes.
Now, the bank which has received this NRRA, which is an underlying avoidance applications, he is coming to another company liquidator and filing a claim. So how is it enforceable? This avoidance application per se is not adjudicated. It's not decided yet.
Not yet.
And it is probably a contingent asset.
Yes.
And 37A says it includes contingent assets.
Yes.
Like avoidance applications can be assigned. So I'm having an issue where a bank is coming to me based on this assignment. I'm a claimant. Please admit my claim. So this is something like, we are seeing a new development. Generally, the NRRA means some asset is there, nobody is wanting to buy, or it is having so many other issues, onerous commitments, something like that. So this is one issue. Then I think we have to see the case laws and also some question and answer sessions. Yeah, private sale during liquidation. I think, Sri, we talked about it. We talked about it. In which cases we can go for a private sale. I think the amendments have made it very clear, perishable, and value deterioration is happening. With SEC, you go. All other cases go to NCLT. Yeah.
So this is from the recent
statistics. Yeah, you can highlight it below.
So this is from the recent statistics of the liquidation processes ending with the order of dissolution or the closure. The total completed liquidation cases as on date, as on 31st March 2024 is 568, in which the compromise and arrangements under the scheme was only 8 companies, and liquidation as going concern is 43 companies, and direct dissolution is of 57 companies.
All other aspects, something like about, if you take about 108 out of 568, so 460 cases are normal cases of liquidation. But I think, Mr. Raghu, more number of cases are going into liquidation. So to my knowledge, I think at least 3,000, more than 3,000 cases would have gone into liquidation. But what have been completed is only 568.
Yes.
In fact, to the audience here, in this session, one liquidation case which we have been handling from 2017, it is yet to see, the closure as dissolution. In fact, we have received some money yesterday, day before yesterday, because we were able to dig in and find out some accounts open still, and the monies have been transferred now based on the order of NCLT. It takes quite a lot of time. So this 568 numbers is representing probably some 20% of overall liquidation cases which have attained closure. Okay, then these are all drawn from IBB.
IBC and quarterly newsletter.
Want to highlight anything here?
So from the first pie chart, it's clear that
more than
the time taken for completing the liquidation is more than 2 years for almost 55% of the cases, or at least more than a year, less than 2 years.
No,
so
that is 19%.
19%. So I think the maximum number of time is taken in liquidation process, maybe of the recent developments, the procedural aspects, the attachments, improvements of this promoters approaching the company, the liquidator. So all this process-oriented things itself is taking more than a year's time. So I think earlier the provisions did give 2 years for liquidation.
Yeah.
Subsequently, it was 1 year. But in practical analysis, we are able to see it's more than 2 years.
Okay.
So for the reasons of liquidation is also majority because of the COC's decision to go for liquidation. So otherwise, the contravention or rejection of resolution plan is all very minimal. So it's not seeing much of a raise because of those reasons.
And in fact, this gives almost about 2,500 cases have gone into liquidation.
Yes,
am I right?
Yes, yes.
So out of that, only 568 we saw the closure. And more than the screen is visible to the participants.
Yeah.
Okay, sir.
Sir, we can't. No, sir. It's not coming here. We can't see the you're discussing the pie chart. I believe we can't see it. We are just able to see you. There's a conference room and some people are sitting. Okay.
Okay. Some people are sitting and some people are saying something. Maybe. Okay. Srishti, we are all the people who are speaking here are also of the same community. And
yeah, completely agree, sir. From the same professional. But yes, definitely, I don't know all of them.
Can you just refresh and see because
okay, so it's a problem only, I believe. Everybody else is able to.
Okay, very good. Next.
Thank you.
Thank you. So now we go on to the important case laws, and we will just take about 15 minutes more, Sri, yes, and then have another 15 minutes for any questions. Okay, please go ahead. God's Asha Chopra and others versus Hind Motors India. This is an NCLAT decision. You would like to highlight something on it?
This is a recent case where the NCLT completely denied that the 12A process is not applicable in a liquidation process. But however, earlier when Mukhopadhyay was there, he has given that even in liquidation 12A process can be continued. And some more cases are there that even in liquidation, settlement was allowed.
Yeah.
But now NCLT has very clearly stated that in liquidation process, 12A is not applicable.
So, if I may add,
yeah.
In NCLT, they had this clear view that only a COC will have to take this decision of withdrawal of Section 7, 9 or 10 petition. So, when the company is brought into liquidation, it means the CRP has been completed. So, there is no COC who can do the process of approving a withdrawal of through a 12A petition. So the court also would have had this opinion that when there is no COC, when there is no statutory provision under liquidation regulations or under the code for withdrawal during liquidation, it cannot be permitted. Yes. So moving ahead to the next judgment.
Hold on.
Yes, sir.
I think maybe for the benefit of the participants, yes, maybe there was a judgment, there was a thing that where an operational creditor wanted to withdraw his case after 9 months. There was a judgment recently within about 3 weeks to 4 weeks where he wanted to withdraw the case And when the matter was NCLT refused to allow him, then NCLT also told that no, being an operational creditor, when he continued the matter, actually the case went on like that. The NCLT fined the operational creditor with the 50,000 rupees that he should pay to Prime Minister's fund, and they were ready to allow him to withdraw the matter. But he was not happy with that, so he went to NCLAT saying that I want to withdraw under 12A and the permissions, systems are available, so I am doing it. But NCLAT 100%, I will have to get the judgment. I remember I read it very recently. Then NCLAT clearly told, no, an operational creditor does not have, he had every opportunity to understand what is the process going on, and he had already continued the matters for more than almost closer to a year and wasted everybody's time, including the financial creditors, all the people submitted claim, everything happened. So you cannot withdraw the case now, unless otherwise you are having an idea of to refile the case, your withdrawal application will not be permitted. This is also the case. You can probably, we may share this case law with the participants a little later. It is also
yes,
there.
Sir. Yeah, I think it's a sensible provision, even though it provides for withdrawing. But by the time so much water has flown under the bridge, how can they just say, then the company is going out?
Yes.
It goes back to the promoters can buy that operational creditor, at least some few lakhs, like what's happening in BCCI and what is that?
And
this was
Think.
Yeah, please think and learn. Okay, next case.
Okay.
Shivalingam Yarma.
So this is one NCLT case wherein we were discussing about the rights of a secured creditor in liquidation, where he has, in the normal sense, he has to give an claim, liquidator has to adjudicate, and then thereafter he has to allow the secured interest to be realized.
Yeah.
Supposing even if that is the case, there is a window that the secured creditor should realize the asset within 180 days, and if they are not doing so, the asset will form part of the liquidation estate.
Correct.
This is the regulation.
Yeah.
But in this case, this is a Chennai NCLT bench case referring to one judgment of Supreme Court. In this case, it would have been held that the liquidator does not have any say to adjudicate a claim of a secured creditor who is standing outside the liquidation estate. So this would give a bad precedent that the section 52 will be overriding.
Mm-hmm. Correct. So probably there will be a challenge to this.
Definitely, I think definitely there will be a challenge to this.
Okay, next case, please. Yeah.
Sir, in Moser Bayer Karamchari case, the issue is waterfall mechanism in IBC versus in Companies Act 2013. So in this case, the Supreme Court held that insolvency and inability to pay debts are instinct from binding up under Section 274 of the Companies Act, and stated amendments to the Act were required due to the enactment of IBC and Section 53 of the IBC. So hence, the court emphasized that unpaid dues are not entirely covered by the proviso to Section 326, subsection 1 of the Companies Act. So it also stressed that IBC provisions cannot be compared with those of previous regime. So in conclusion, the court highlighted that altering the waterfall mechanism could disturb creditors' rights and lead to instability. It also affirmed that Section 326 and 327 of the Companies Act do not apply in case of the liquidation under IBC. It's not arbitrary or violative of Article 21 of the Indian Constitution. So this is the observation about the waterfall mechanism in IBC versus in Companies Act.
Even though it is more than a year-old decision, I think it reaffirms the superiority of IBC, waterfall mechanism, and also kind of importance given to the employees. I think this is more in relation to the 326 itself is talking about employee payments.
Priority of work payment during winding up under Companies Act.
Correct.
So if I can add, the court in this matter would have observed the initiation of IBC, the reasons for bringing in IBC, and the court would have clearly stated that the intention of IBC was to bring uniformity in payment and also to give priority to certain type of payments. Though 326 and 327 of Companies Act state that workman dues will be on top, irrespective of any other dues during winding up, there would have been an insertion in the Companies Act through IBC, which amendment stated that 326 and 7 will not be applicable in case a company goes to liquidation under IBC. So this particular amendment was only challenged in this case. So the court would have stated that intention of section 53 was already to prioritize workman dues. That is the reason why they are brought in top in par with the other secured creditors. So there is no requirement to venture into the constitutional validity of the amendment. So they have upheld that section 53 is giving a proper recognition to the workman dues.
Absolutely.
Yes, moving ahead to the next case.
Yeah.
Okay. In this case, the issue came forward was whether moratorium under section 33 subclass 5 of IBC during liquidation process bars on adjustment of income tax refund with past dues, and whether on completion of income tax assessment proceedings during liquidation, the income tax department can avail of set of suo motu. So section 14 of moratorium in CARP that prohibits both institution and continuation of pending suits or proceedings against the CD. In section 33 subclass 5 of liquidation process of moratorium, it only bars the initiation of new suits during the liquidation process. So there is no bar in a suit or a legal proceedings continuing along with the liquidation process. In this case, the set-off has been claimed after the passing of the liquidation order, which is legally permissible under Chapter 3 and Part 2 of IBC. The income tax authority enjoys limited jurisdiction of continuing with the assessment proceedings and in determining the quantum of income tax dues, but it does not have power to suo motu or initiate recovery of dues or execute their claims unilaterally by adjusting the income tax refund amount with past tax dues. So while applying the principle of set-off, it must be kept in mind that no creditor ends up in getting shares disproportional to their dues.
Okay.
So this is what they have been found in this case.
It's a very important case because income tax department, just few days ago, I saw, where I was to get a refund, immediately, on seeing the mail, I was happy that there is a refund coming. Just after that, one more mail came, your refund has been adjusted against past dues. What's all this going on? So you are not sure of getting a refund unless it comes and hits your account. So in my case, the money has not come yet till date. So I don't know which one came first, refund or the attachment, adjustment. But I think in the IBC matters, the things have been put very clearly that while the authorities have the right to determine or assess, they cannot adjust the income tax refund. Okay, next case, please.
Okay, so in Tapadia Polyesters Private Limited, this NCLAT's judgment where there was an attachment of assets made by the sales tax department even prior to commencement of CARP. But this particular attachment, which was made prior to insolvency, would have continued throughout the process, throughout the liquidation as well. This particular attachment was in question before NCLAT because the liquidator would have brought this asset into the liquidation estate. The court would have clarified that though the attachment was made prior to the insolvency process, the ownership of the asset will not go to the statutory authority. The ownership would vest only with the corporate debtor, and that the asset can be constituted, can form part of the liquidation estate. So this attachment is only a question of encumbrance. So the liquidator always can take a recourse under the Act to remove the encumbrance to make good all those attachments. So the estate would still have this asset included in it. So I think this can come to the rescue of any companies where there is attachment of assets. So if we may move for any questions from any participants.
Yeah.
Can you please, repeat the previous slide?
The previous case law, sir?
This attachment part, yeah.
Yes, sir. So the code would have clarified that in case there is an attachment of asset, it would constitute only an encumbrance. The asset can still be brought into the liquidation estate of the corporate debtor, irrespective of any attachments.
Even in 36, section 36, it is clearly given that asset which is being encumbered forms part of the liquidation estate.
Correct. So this is only a clarity so that the liquidators don't leave aside the assets which are encumbered, the assets which are attached by statutory authorities.
Sir, any of the
so this attachment cannot be removed when the CIRP process is initiated?
You can take actions for removal of attachment. You need not leave aside the asset. You can still put it in your asset memorandum, bring it.
Your voice is cracking.
Okay. Sir, it is like this.
What I mean to say is then...
Yeah, are you able to hear us now? It's okay?
Yeah.
Sir, the point highlighted here, the attachments made by any authority, whether it is Benami Act or under Income Tax Act or the Commercial Tax Acts, they are attaching the assets of the company against the dues of the departments, but the liquidator being the person in charge of the corporate debtor, which own the assets. The ownership is with the corporate debtor. Am I right, sir? So when it is owned by the corporate debtor, the liquidator has the right to deal with the asset because it is in liquidation estate.
So we can write to the income tax department or sales tax department stating that if they have a claim, let them file a claim with the liquidator and the claim will be settled as per 53, whatever it is, as per the provisions of the IBC.
Yeah.
So they cannot say that I will not file the claim, but I will retain the attachment.
Yeah.
So if the liquidator writes to them and if suppose they are not going to file any claim, even the liquidator can sell the asset and the attachment can be removed straight away by the NCLT, giving 32A protection.
Yeah.
But technically, the most appropriate way is to first get the attachment removed, maybe through the order of the NCLT or NCLAT, by the resolution professional, say RP or the liquidator, and then, they can deal with the asset and let the statutory authority file the claim with the liquidator or RP, whosoever it is.
Yeah. It's also a good point. I think in one case of EPFO in Krishna Industrial Corporation, they attached. I think we had to go to NCLT to remove it, or they themselves removed it. I don't remember. But what Mr. Anil Uchchandani is saying, why don't you file an application IA before NCLT, seeking a direction to them to remove the attachment?
That can be done. That is only for removal of encumbrance. But when you form the liquidation estate, immediately upon commencement of liquidation, so you need to take measures to take control of the assets, form the liquidation estate, file asset memorandum to the tribunal. So all those processes, you can include this asset. To remove
my point is, sorry to interrupt. My point is that, while the asset is attached with the income tax authority or whosoever it is with, how can you include that asset in the liquidation estate? Because you'll not be able to auction it or sell it till the time attachment is there.
I think, Sir Anil, we squarely disagree with you on this point, because the attachment by commercial tax people does not mean that the asset cannot be sold. It is only that the authorities under the IBC process, they should have given a claim to the RP or liquidator. They should have given a claim.
Supposing if they are not giving a claim, we'll have to write to say that let them file a claim with the liquidator.
Correct.
No, sir, my point is, My point is that, you know, any person who would like to buy the asset, they will like to buy the asset clean, you know, free from any, you know, attachment or encumbrance. In any case, you know, it will be difficult to find a buyer if a buyer knows that, you know, this is already under attachment and it's not clean. So, you know, buyer definitely would not be interested. Everybody will be hesitant to go for buying of such asset, you know.
Sir, your contention is true if the company is not under IBC. In those cases, probably what you say is true. If the buyer is buying the asset with some attachment, he will be worried, but not when the case is under IBC, because IBC gives you a protection. 32A protection is there.
That is what we discussed.
That is
the value, the advantage, the dilemma advantage can be taken by the buyer, and the value can be reduced to that extent.
Yeah, exactly. But your point, Mr. Anil, that you first clean up all the attachments, remove the attachments, and then you go for sale of the assets. I think on the timelines, you would have crossed easily 5-10 years, because no statutory authority is willing to remove the attachment. I'm talking to some authorities now in a case which is running for the 4th year in liquidation. I came into the picture only some 2-3 months ago. They are not willing to remove the attachment.
In fact, this is the problem one of my friends is facing. You know, they are not able to sell the asset and dispose of, you know, because the asset is already under attachment by the Industrial Development Authority, who were the earlier owners of the land. Now they have been stuck for 3-4 years now.
We have a solution for that, sir. So we can discuss in you know, in person later, on a one-to-one basis later. But you have a solution on that. Okay.
Sir, may I request if you can kindly, you know, share the slide or circulate the slide through the IPA?
Sure, sir, sure. Yeah. We will share it, sir. We'll share it. And I would like to call upon, can you please remove this thing and go to our screen, full screen. Sir, may I request the other participants? There are at least, how many of them, Sri?
Now 30.
More than 30 participants are there. We have been interacting only with some 3 or 4 participants. How about other persons? I would like to call upon a few of them. Mr. Kamal Tayal, Praveen Ranka, Mahesh Chand Gupta, Rajiv Ramesh Shah, Anand Kumar, Mr. Pawan Garg, Mr. Deepi Gupta.
Sir, I have a small question.
Yes, sir.
This is regarding that SEC and all, because both I can understand after this 12th February 24, there have been a lot of focus and like to bring the most clarity, the role of SEC is emphasized. But in some cases, like where there are no outsider claims, like maybe the typical case of voluntary liquidation, where there are only shareholders. So is it has to be formed mandatorily, like SEC and some, because earlier I think there was view like this, if it's simple case of voluntary liquidation, then you go straightforward and file the case after for dissolution. But is it required under your view to form an SEC formally and make some minutes and all?
So whether it is a voluntary liquidation or liquidation process, sir?
Voluntary.
Voluntary.
Separate regulations.
There is no requirement for an SEC in a voluntary liquidation.
Okay.
Voluntary liquidation regulations are
there is a separate regulations which governs the voluntary liquidation.
2017.
Yes.
I think there was a session yesterday on this matter.
Yes,
yesterday. Okay, Mr. Rajesh. And any other participants to have any questions or comment or views?
So could we have a few of those case laws shared with us where there was a compromise or arrangement or corporate as a going concern that was sold, just for reference, so that, you know, like a little more extra clarity can be sought besides academic interest?
Yeah, surely. One case which I shared with you, probably I think you can just Google it and find out that Sterling Biotech, which is sold as a going concern. Liquidation. And in Chennai NCLT, there has been 2 cases at least, Ambika Sugars and Thiruvaruran Sugars. In both the cases, it is Section 230 approval.
Yes.
Nagarjuna Oil Corporation also a 230 approval, but it is still in a limbo. I think it has not been implemented properly. There has been a lot of disputes going on. So 230, as we talked about it, recently, Ms. Kamak, I think it is slowly taking shape. But for the time, lapse, so much of time it is taking. If it is improved, probably I think many people would like to come under this 230 process, probably. So, Mr. Gupta, sir, you wanted to ask anything? Mr. Gupta?
So if the creditors do not relinquish their rights, just an extreme question that like, suppose there's a creditor who has got 100% of the assets secured, not the business, and they do not want to relinquish their right. They have put in a claim, and they are in a position to sell these assets, of course. How does it really work for the workmen and the rest of the creditors in such a scenario? And of course, the company remains, and maybe some intangible assets remain in the company. But if this is a scenario,
yes, there is a 21A regulation.
Yes.
Right?
Yes. But I mean, regulation 21A, it states that even if they are standing outside the liquidation estate, they are supposed to bear the liquidation cost, whatever priority cost that are supposed to be paid to the workman and thing, that they are supposed to give it to the liquidator. Within 90
so they will have to give the PF dues and the gratuity dues, is what you are suggesting.
Yeah, that estimate you will have to, as liquidator, you will have to give the estimate to them, and they will have to give this amount within 90 days of the liquidation commencement date. Supposing
if they decide to not relinquish the asset, they have to first pay whatever the priority costs that are due to the third parties, including the CIRP cost and the cost to the workmen, right?
Yes, ma'am.
And this has to happen in the first 90 days.
Yes. Supposing if they are not able to sell the asset within 180th day, then the asset forms part of the liquidation estate.
Okay.
Raghu?
Yes, sir.
Yeah, probably Kanak, what she is asking on that is, you are right, madam. See, please understand whether the liquidator is selling the property or the secured creditor is selling the property. After the property is realized, first, always it is before the line, that is before the section 53 starts, there are certain things which are called the payments which need to be made out of the proceeds realized. It includes the PF dues, it includes the CIRP cost, liquidation cost, all those things will have to be given across out of the realized proceeds of the property. To the extent,
in that case, in that case, 90 days will not be applicable, because your proceeds may get realized at a later date, say after 3-4 months. Maybe
also. Even if it is sold, if by the proper, if the secured creditor sells the property even later, the first thing first, they will have to, actually what is happening, they are realizing the property on behalf of all the people, and that section 53, above section 53 line will have to be taken care to the extent of their holding. If suppose they are 100% out of the admitted liability, then they will have to pay the entire cost of liquidation, all the PF dues, all those things, then only they can take the remaining.
So the thing that now, like when you talk about secured creditor, they may have secured the entire assets of the company. Although proportionately in the SCC or the COC, they may be, say, for argument's sake, like presently we say they're only 50%.
then
So
they will have to pay only 50% of the cost.
Then the balance people who are not getting anything out of the liquidation process, will they contribute to the 50% is a question then?
That is a point which has to be taken care of. But to start with, because the remaining 50%, there are some assets, right?
No, there will not be any assets, because some of the secured creditors secure the entire asset to themselves, and the balance, like your ICD holders and like somebody who contribute for short-term finances or your channel finances for that matter, they will not really have anything in terms of a security.
That is the reason why when a secured creditor, maybe Mr. Rajendran can substitute on that, when a secured creditor is going to have his own realization done, he is supposed to tell the value at which he is planning to sell the property. That also should be declared in advance.
Now, if they declare it, but my question still remains as to why will the other creditors who are not getting anything from the process, for that matter, like even if it is secured VAT department, why would they contribute to 50% when they're getting nothing out of the process? Just
even
because
if
they are claimants here.
Madam, in this case,
sorry, Raghu. If the property, even if the property is sold under liquidation by the liquidator, this creditor, being the secured creditor, he or she will be only getting the entire money, right? The other creditors will not be getting anything.
Yes.
That's what.
But then they have to pay the CIRP or the liquidator's fees. Who's going to pay the fees? It can't be 50% short because,
Madam,
one creditor has taken over the entire assets.
Yeah. Sir, 1 second, sir. 1 second. I think Raghu will clarify on one point.
Sir, if it is only one asset and the entire asset is being taken by one secured creditor, then that secured creditor has to pay whatever priority payment as if he has relinquished the asset.
That is in full. That is in full. He has to pay.
That is in full. Yes, the entire CRP cost or other dues that is prior to whatever he is going to take. Before that, whatever amounts he is supposed to pay in liquidation process, that he has to pay.
100%. Probably that is what
you can refer for regulation 21A subsection 2. Clause 2.
Yeah, Ms. Kanak, I'm just wondering, perhaps I was also having that kind of an idea, when I came into IBC, that we should not be handling liquidation. We should be only doing resolution plans. Incidentally, you be doing only resolution, I think. Have you got into any liquidation?
Not yet. I've been only into resolutions. Probably I've been able to get resolutions for the cases.
But you're preparing very well.
I have to, because obviously, you have to have a comparative to understand what happens if scenarios, And obviously, you cannot be doing CIRP all the time. Everybody who's now, like sir just showed us the statistics about 1,700 odd companies going into liquidation. So in that case, obviously, one has to be prepared for that scenario also.
Absolutely. In fact, we had very interesting litigations on 21A. The person, Mr. Raghu, was telling one single creditor holding, squatting on the asset, and he was not even paying the money to us. Finally, NCLT gave a contempt. We filed a contempt as the liquidator.
For getting that money, the share of that, whatever you were telling, that the liquidation cost that he has deposited, and also after 188 days, we got that asset into our liquidation estate, and finally we sold that asset.
And that is from a state financial corporation.
Wow. So these are practical experiences, which we probably get only, or the insider views only once you have practically worked on a case.
Exactly. And we find, we find you have handled a listed company also, right, on the CIRP.
Yes.
That's very interesting in the current context of now SEBI coming into the picture and fighting on behalf of the existing shareholders. You cannot just leave them empty-handed going out. Anyway, IBC is a very interesting thing, excepting that, the number of cases have completely dried up. Small. And we would like to invite questions from other participants? Anyone, any other person? Yeah, we got only another 10 minutes to go.
So if you could share your coordinates as well, maybe, you know, we just, if you're okay with it, we may want to get in touch with you for any questions at a later point in time.
Yeah,
if you're
absolutely
comfortable with it.
Yeah, we also have in our team, Mr. Nageshwaran is a very experienced banker. He was with State Bank of India for several years before getting into the insolvency practice. And we also have Mr. Nandakumaran, is also a retired banker from IOB. He has handled a lot of IBC matters when he was in Mumbai. I think cases like you were mentioning about few SR Steel and a few more cases.
Wow.
Yeah.
Rusdev International,
Yeah.
Unity Infra.
Unity Infra is a real estate.
They constructed the contractor, bankers financed the contractor for constructing a hospital.
In fact, Unitech was the case where they demolished the building. No? Huh?
Unitech is different.
Unitech is different.
That is also a listed company.
Yeah. So I think, sir, I'm sorry.
Almost 5 o'clock. Any other questions we can take?
Yeah. So one last question from any of the participant from the team here, or may I choose that person who will ask the question? Well, I would like to ask Mr. Shanmuga Sundaram. Is he there? If he is there.
Yes, sir. You are talking about me?
Yeah, Mitali Shah, ma'am. Yeah.
Okay. Sir, the idea is, it's a very peculiar situation wherein which we are currently at a moment. So we are running a liquidation mandate. The mandate had started somewhere around 2018, 2019, at the beginning of 2019. And it's a cinema business per se. It is a 3-4 business. One of the businesses, cinema business. At that point in time, the asset base was very good. The cinema were running very fine. But by the time we make little progress, that COVID hits, and thereafter the entire situation has been changed. In 2021, of course, the cinema were closed in the COVID. And in 2021, the ED has done the attachment on the entire assets. Now we have requested after that, since last 4 years, we have requested many a times to NCLT, ED court, ED appellate court, and CLET to help us to release some charge so that we can sell those assets, but somehow nowhere our pleadings are considered. So in such a scenario, the lenders are also now frustrated, the SSC is also frustrated. We are also stuck because we are not getting our fees and nothing is moving further. Even the value is also deteriorated to a larger extent. So in such case, sir, what do you feel that where should we go and how should we take it further?
It's a difficult question, I think.
No, this attachment with by ED is relating to what offense, madam?
Sir, it is on the entire company. So entire cinema business, the real estate assets, everything is attached. Even the cash which was coming through a cinema business, because we were also the RP during the CIRP process, and they have a large cinema chain across Delhi NCR. So the cinema business was getting a handsome revenue. So the entire cash is also frozen by the ED.
Okay.
This attachment under PMLA?
PMLA, yes, sir.
Okay. So even under PMLA, we have seen interesting decisions that the attachment can be removed by the NCLT under section 32A. If there is a resolution plan by a new management or sale to a person within 29 eligibility, you can do that, Ms. Mithali. We can do that.
Okay.
There are possibilities of working around a solution. I think I can add here that we are handling a case where there is a attachment by about at least 4 people, under Benami Act and under Income Tax Act and Commercial Tax and GST. But still, we are going ahead and then trying to find a solution. If it is possible, it is not in a resolution stage now. It is in liquidation. The company is in liquidation. So we are trying to sell the company as a whole. If we are succeeding in that, the person will take all the assets of the company, have 32A protection. That is what, a possible solution we can try.
So that 32A will be granted by the respective NCLT, right?
Yes.
Yes, madam.
But unfortunately, on our party, sir, so many cases against us as a liquidator, against us as an RP, because they have, a depositor business as well. So single kind of depositors were also there in one of the business. So they have done so many cases against liquidator, and we have also gone to various authorities. But nobody is, listening us. Even the NCLT, when the name of the corporate debtor comes on the board, they will just simply give us the date.
Okay, I think what you have been telling is more
operational challenges.
Underlying current, operating against the individual insolvency professional in that particular bench. Probably I think we'll have to wait for some time to expect a change or something like that, or I don't see any other, or change of counsel probably may be able to help.
Sir, is there any likely change, because IBC is very well prevailed during CIRP, but is there any card that it will also prevail during liquidation in the expecting amendments?
I'm not NCLT president. I'm not NCLT president. Well, gentlemen, ladies and gentlemen, I think we have come to the end of session, and I profusely thank all the participants, even though they have chosen not to disturb the proceedings, not to ask any questions, but still only a handful of them have made active participation. Thank you very much. Among them, Mr. Anil and Ms. Mithali and Kanak, Jani and Mr. Raj. Thank you very much for being available throughout the session with our team. And I also thank our team members here who have taken active interest to prepare and present whatever knowledge, whatever little information, kind of experience we had in the past few years, we have tried to put across. But nevertheless, it is a continuing journey and a lot of learning. What we have learned yesterday probably may not be helpful for us tomorrow. We need to keep continuously learning. And thank you very much, Ms. Anjali. If you are there, I request to take over.
Thank you very much, sir, for such a nice session. Thank you all the participants for patient hearing. Thank you very much, sir, and his team members for their contribution and valuable thoughts about the topic. Sir, I can request that you can share PPTs to us.
Sure.
Thank you.
And so also your contact number if possible.
Yeah, we will put the CGRF contact number.
We have it in the PPT itself.
One time the first CGRF
coming number.
Last version.
Chat box la போட முடியாது.
Yeah, we will share it in the chat box, and also we will just share it on the screen as well.
Thank you. Thank you, Rajendran sir and entire team. Thank you so much.
Thank you.
Thank you, ma'am.
Thank you very much, ma'am. Thank you. I can just quickly add here that the website which we have shown here, we publish a monthly newsletter called Sandbox, and that contains a lot of information about IBC, the corporate laws and recent decisions, and we are doing it on a monthly basis. We have almost for the 5th year we are doing it, and you can download the newsletter from our website. And in case you want to have it on a continuous basis, you can write to our email ID, createandgrowresearch@gmail.com. It's a Section 8 company. It's a non-profit organization, and we have been doing this knowledge sharing, almost for the past 5 years. So you can contact us through this email ID, and also you can download it from the website www.createandgrowresearch.org. Okay. Nageshwaran sir, you want to say something?
No, we have the thing. Probably, as some of them asked, maybe ICSI, through ICSI, we can share some of the case clause detail what we had discussed today.
Okay. Thank you, sir. Thank you very much. All the participants. Thank you. Thank you. Thank you, Ms. Anjali.
Thank you very much, sir.
Thank you, sir. Thank you so much.
Thank you, sir. Bye.
Anjali, please share the presentation.
Thank you so much, sir.
Sure, sir. Sure. Yes, sir.
Anjali, are you there? Sir,
Yes,
would you kindly share the presentation?
Yes, sir. Sure.
Yeah.
Thank you, sir.
We can send it across to ICSI and they will share it with all the members.
Right, sir. Right, sir.
Thank you.